All right. Good morning, everyone, and welcome to the task force on the rules of the Supreme Court of Arizona. See, obviously, many familiar faces. We have a long list of esteemed guests who are going to be joining us, mostly online and some present here. A list too long to address folks individually, but I'm sure we'll be hearing from all of you as we proceed. Please feel free to weigh in whenever you deem appropriate. We look forward to you sharing your expertise with the task force. We've got a busy day as always. We'll be hearing, and I will address the order of presentation of the work groups, but we have 4 of the regularly convened work groups, and also I'm going to provide at the beginning of that process an update on the Rule 122 work groups process and the status of the petition, which the task force approved a couple of months ago. And so I'll go into detail before we commence the substantive presentations from the other work groups. So with that, I will turn it over to Justice.
Good morning, everybody. The next item on the agenda is just the approval of the minutes for our last meeting on April 2nd. The meeting minutes, the draft begins at page 4 of your meeting materials. And does anybody want to discuss or have any comments? None. I just need a motion to approve in a second.
So moved.
Second.
All those in favor say aye.
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 Any opposed? Motion carries. Thank you very much. And I think I'll turn it over to Justice Lopez.
All right. Now to the heart of the matter, the work group presentations. As I mentioned, I'm going to give a brief summary of where we're at on the Rule Petition 26003, which concerns Rule 122, and which, as I just mentioned before, the task force has previously approved. The petition was then subject to comment period, and so we're at the end of that. I want to give you an update on where we're at. So just this last Friday on May 8th, the work group for Rule 122 met. We discussed the comments. The comments were generally favorable on substantive matters. There were a number of comments suggesting to improve the language of the petition. We found the state bar's comments particularly instructive in this way, and so we will endeavor to adopt many of those proposed changes. However, we received one comment in particular which had extensive concerns about the substance of the petition, and that was crafted by David Bodney and Matt Kelly on behalf of the Arizona Media Association. The thrust of that comment, if you haven't read it, concerned the effect of the petition as written on media access and generally on the court's longstanding policy in favor of transparency by facilitating ready and largely free access to the media to cover court proceedings. Because we deemed the issues raised in Mr. Bodney's petition to be largely meritorious, we welcomed or invited David Bodney and Matthew Kelly to our work group meeting to discuss their concerns. And from that meeting of about 3 hours duration, we reached consensus in my view, on a number of issues. The first is the fact that our judges and parties, witnesses, victims face real and pervasive challenges to the proper administration of our court, and that those concerns, at least in part, may be mitigated by revisions to Rule 122 and 122.1. We also agreed that by improving clarity, thus notice for judges, citizens, and journalists, and anyone involved in a court proceeding, that improved clarity would give everyone a better understanding of exactly what the rules allow, what they preclude, which would give the judges more confidence to enforce those rules, but also provide individuals who are acting in good faith a better understanding of what they can and can't do. And by virtue of doing that, perhaps eliminate unnecessary confusion, misunderstanding, and conflict concerning coverage with recording devices inside of our courtrooms. The third point that we also reached consensus on after discussing the comments with Mr. Bodney and Mr. Kelly was that the petition as drafted likely unintentionally complicates and may even risk curtailing media access that we have traditionally recognized by operation of Rule 122, and that there are revisions that can be made to eliminate or certainly reduce that risk of causing confusion for professional journalists acting in good faith, just doing their jobs. And of course, everyone here understood that that was not our intention. But Mr. Bodney raised a number of issues that we think can be remedied by revising the petition. And so we're going to be working with Mr. Bodney and Mr. Kelly to ultimately arrive at revisions in addition to those that we will likely implement from the State Bar and other comments to represent the petition to this task force for reconsideration and hopefully ultimately approval. Now, with respect to the timeline, as it currently stands, our reply to the comments is due on June 1st. We're going to have to seek an extension of time for that. We can't meaningfully address these concerns, improve the petition, and present it to this task force by June 1st, of course, because we don't meet until after that date. But even beyond that, we may not be ready to present a revised petition by that meeting, but certainly we should be able the next. So we will seek an appropriate extension of time to address these concerns and represent it. So we will keep you apprised of our progress. I'm very confident and encouraged that with all of the input from the comments and in particular addressing the concerns that Mr. Bodney raises on behalf of his media clients, that I think we can accomplish both tasks. I think we can improve clarity and also emphasize the consequences that the law permits for conduct that violates Rule 122, and when an individual makes a violation and is apprised of that by a judge, that there are and will be legal consequences that go beyond perhaps just matters that involve disrupting the court, like a contempt proceeding. And that's generally been the problem, I think, as all of you may recall. It's not the Rule 122 violation that would give rise to attendant criminal consequences. It's the conduct of the actor when apprised that they may no longer record in a courtroom because they're violating Rule 122. We're going to clear that up, but we're also looking at including language in the rule which will make clear that someone who does not comply with a court's directive to cease recording, that they may ultimately violate other criminal conducts like trespass, harassment, and the like. And so the way the rule is currently crafted, as Mr. Bodney, I think, reasonably points out, it reads as if there are some hidden statutes that would criminalize a violation of Rule 122 in and of itself, which certainly was not our intent and doesn't reflect the state of the law. So that's where we're at on Rule 122. Any questions for anyone before we move on to the other work groups? See no hands. All right. Okay, so we'll move on to the other work groups. And so I believe, Mark, that we've apprised the presenters of of the order in which I'm about to announce. So I don't think anyone's caught off guard. But for all of you who are not privy to those communications, we'll hear first from work group 3 and then work group 4, followed by work group 2 and then work group 1. So with that, we'll open the floor to work group 3.
That's me.
All right.
Aaron is the chair of work group 3, but I'm the chair of the Committee on Character and Fitness, and these rules are particularly Committee on Character and Fitness Practices Procedure. Now, I won't ask for a show of hands, but I suspect most of the people in the room did not have much difficulty with character and fitness when they got admitted to the bar, but many people do. So it becomes very important because that's your initial licensing, it's your life, it's your profession. And I got on the committee. I was sort of surprised to see how often the Supreme Court has to get involved in these cases, that there is provision for petitions for review, and they happen all the time. And the strangely aspiring lawyers read these rules with precision, and many of them have disagreements sometime with the application. So they ask the Supreme Court for clarification, often for waivers, that the Supreme Court can waive rules, and they often do. It's amazing how often there are unique facts that come up in applying these rules. I think we hear all the time, well, I never thought about that. Or somebody has a unique circumstance, something as simple as requiring graduation from an ABA school. You get somebody who went to the university or Oxford University and then practiced for 10 years in New York, and they want to get admitted in Arizona. And so what about the ABA requirement? So for decades, the Supreme Court has on an individual basis looked at those. And so it highlights how we have these rules are designed to be very general, but also be very specific. And the process is, for most people, very straightforward. Most people apply, they have no problem, it gets approved. But we want to have the rules written in a way that it allows that simplified process, a very simple process for most people, and yet also retains enough detail to look at cases that require attention, and also then provide fairness and due process in the whole process. So as you can see, we have most of the applicants will just be admitted without any formality. Staff will take care of it. Members of the committee don't even touch it. But if there's any issue, we try to be very informal at first and provide for review and allow people to present information about their practice and try to resolve it very informally. But then it can ratchet up to what's a hearing, as we try to define it as a hearing, not necessarily a formal hearing, because all hearings are now going to be formal. But allow for that process where there's evidence introduced, there's often counsel, though not always. And then if there's a disagreement, that can go to the Supreme Court on petition for review. So the rules try to reconcile all those factors. And so, and the rules have been changed a lot over the years. When most of us were admitted, it was fairly straightforward. You took the bar exam, you passed, you could get admitted. There weren't many other options. But over the last 20 years, particularly since admission on motion was enacted, these rules have changed all the time. In fact, there are several pending petitions, no pressure on the Supreme Court justices, but if they grant those, we'll have to go back and redo these things. But which I think is true with a number of rules. But there's also often, people, practitioners, applicants, our own committee suggesting improvements, suggesting changes. So these have been changed a lot. And so tracking how and why becomes an issue. But we have lots of institutional memory. I see Ed Novak's on the call. He was chairman of this committee for about 10 years. Aaron, before he was the clerk, was supervised the admissions process. So we work with them, with Marianne Nystrom and with Lisa Bannon, the chief staff attorney, who I think ultimately for the Supreme Court on petitions for review and rulemaking has a lot of say. So we have a lot of institutional memory that we try to bring to these things. And everybody else sort of reading it cold in terms of saying, we don't really understand that. That's very helpful. So feel free to say. But the rules we looked at are to start with existing Rule 36. So it's on page 34 of 98 of the packet. And I want to thank Aaron. Aaron gave me his notes, so I'm following along those lines in terms of the presentation. But he's happy to to have me take the lead here, but he's certainly available and other reports are available. So starting on 34, the rules cover 5 of the 7 rules related to character and fitness. We haven't quite got to the conditional admission, which is important, and we'll probably bring that back next time. And so this is a lot of the processes, laying out the groundwork, again, trying to inform applicants in a very simple way as to how the process worked and yet retain enough detail to fill the gaps. So in terms of, we do have some substantive changes, which we don't necessarily think are substantive so much because they incorporate existing practice, but we'll do that. So 34.16 is Committee on Character and Fitness procedures. Generally, A through D are pretty much restyled, intended to conform to the language and other rules, trying to make it consistent between them. Provide for, talk about a special investigator, talk about the bar counsel. For the most part, those are never really triggered. The bar is not directly involved in the admissions process. It's permissible if we ever get a really contentious case, perhaps. But for the most part, the staff looks at the application. If there is an issue with some sort of character issue, it involves substance abuse, financial impropriety, criminal activities, it gets referred to a member of the committee. Members of the committee have a wide range of functions and they can act as an investigating member, and which means sort of a lawyer for the committee. And on the other hand, they act as administrative law judges, hearing the cases in either an informal inquiry or a hearing. And so it's a dual function. So the references to special investigator and the bar are in the current rule, and we, for the most part, retain them and yet try to clean them up stylistically. The work group did put language in 34.16C1 to have language in one place about copying the applicant's counsel. The rules were not real clear about if somebody had counsel, what you do with that. Because and for the most part, most applicants do not have counsel, but they certainly have the right to do it. And the rules had several different places and saying it in somewhat different words as to how to keep counsel informed. We have had some debate as to what that means if they have counsel. Is that like a transaction where now you can only communicate through counsel, or can you communicate directly to the applicant with a copy to counsel? And the rule generally allowed copying to counsel, but the terms were a little vague. So in the A1, we just now say a copy of any written communication to a represented applicant must be provided to the applicant's counsel. So they're always on board. And as I say, most applicants do not. Even applicants who go to formal hearing often do not have counsel. They represent themselves. The ones who do a great job generally are admitted because they sort of prove to us that they're good lawyers. They represent them. And so that's and some counsel, some applicants who go to an informal inquiry should have had counsel. And that sort of leads them to think that they can sort of walk over things. So that's rule 34.16. John?
I just had start with A, referred to as sui generis, and one of the styling principles is to stay away from Latin. So I would suggest saying either it's subject to their own unique rules or it constitutes a category of their own. And it seems to go with that sui generis means. In C1, a little concerned with the first sentence. It says the applicant may be represented. Are you trying to say that the applicant has the right to be represented?
I think so, yes.
Because otherwise it just says, well, maybe they will allow it, maybe we won't. I was concerned about the second sentence that was a little ambiguous. It means the issue is if he is represented by counsel, do you communicate only to counsel, or are you just going to be sending an additional copy to counsel? This additional copy, then all you need to do is just add the word also after the word applicant. If the intent is to make sure all communications go just to counsel, then that would require drafting a different sentence.
And I think the intent was the latter, that because the rules are, it's this comes back up to sui generis, actually. These rules are just different in terms of the direct communication.
It just goes to council.
No, it did. A copy goes to council. So also.
And if you just put in also, that will. And I had some problems with D. The first sentence refers to your governing depositions, so proceedings within and outside the state. I'm not sure exactly what that means. Are you suggesting there's a different set of rules that apply if a deposition takes place outside of Arizona?
I would have thought there were differences in rule, but I've never done depositions outside the state, so I couldn't tell you. So
I don't think, I mean, you have to follow certain rules to get a subpoena issued outside Arizona. Maybe that was the intent.
yeah, that's a language in the current rule, so we just took it.
I'm not sure what it means. And it also refers to the rules of procedure governing depositions and civil proceedings. And that may be a little too broad because Rule 30A, as you know, it's got restrictions. It has specifically lists who you may or may not depose. You have to go to a court to depose anyone besides the parties. And I don't think that's the intent here. And you shouldn't have to go. I think the intent is you go to the chair to ask for subpoenas to be issued, but you don't have to ask to the chair if you may depose certain people. And two has A2 also has limitations dealing when you can take depositions. And I don't think that was the intent here either. So I would suggest, but I think the general procedures in Rule 30, what you were trying to get at. So I would put as a prefatory language that for Rule 30A 1-2 is applied. I think the intent was the mechanics of how the deposition works. And there's also at least some procedures in A dealing with if the person's incarcerated, how you can depose them. And that you can compel the attendance of under Rule 45.
And do we need civil twice in the first sentence in D? Can we just say the rules of civil procedure governing depositions? You don't need in civil proceedings.
I think you can get rid of it because I think the reference to within and outside Arizona is confusing. So if you just say the rules of civil procedure governing depositions are applicable, and I think you're okay. In the second sentence, it refers to you can issue subpoenas. Would suggest including a clause consistent with Civil Rule 45, because there are two rule sets that family law has their own subpoena rule, So I would be more specific to which subpoena rule you're referring to. And if you refer to Civil Rule 45, you don't need to include inclusus tecum. It's apparent from the rule itself that you can get documents. And I would also encourage you to not use the word thereof at the end. You can have an archaic term. Maybe to say, or any continuance of such a proceeding.
Aaron's notes say John will suggest taking out thereof.
Going back to paragraph A, is there a reason why that's there? I mean, it's obviously its own proceeding because it's got its own rule. So why do we need to describe that are neither civil nor criminal? What does that add?
Well, that could come up.
Yeah.
We have a case pending in front of us right now where that distinction are in the matter. But I'm not saying that.
Do you think that
That
needs to
picture-
be described as its own thing, that it's not civil, criminal, it's
Well, if the rule wants to make the distinction, then the rule should make the distinction.
Yeah, so we use that same term for the discipline. So first of all, I appreciate the mirroring. So while I understand what John's suggesting, I would disagree. I think the sui generis is intentional and necessary because when you're looking at just how in general to view these particular rules, certain entities may want to argue this is like criminal and you should be doing it like criminal. And so by clarifying, this isn't like anything else. So it isn't like a regular administrative issue. We aren't in the ACJA, for example. I think it clarifies all of that. So it does, in my opinion, it does more than just say it's not civil or criminal. It's its own separate and distinct thing. And I see Pat, who's far more schooled on this than me. I don't know if you want to weigh in on that.
No, I'm agreeing that, and it's the same language. I just looked it up as what we were in the current draft of the working version, saying that language is still in the discipline rule as well under the changes. So
I have a question. I don't want to get away from this, but I have a question about the representation part. And so if you're in criminal or civil, if I'm representing somebody, I file a notice, but do you all have filings? I mean, this is how ignorant I am to how process works.
And I think the answer is, it sort of depends. I think that the rules talk about petitions for review are filed, but for the most part, I say they're submitted. People send them in. People do file notices. The council do file notices of appearance, and they use the caption that's in the rule. But it's they essentially email them to us.
Do you consider someone to be this counsel for purposes of the copy if they haven't filed a notice? That was kind of where my.
I think it's fairly informal. If they send an email saying I'm representing so and so, that's probably counted as a notice of appearance.
As long as we have a writing confirmation they are in fact representing the individual, because otherwise we can't talk to them because of the confidentiality that we're going to get to later on.
We try not to do gotchas, people. So
Yeah.
in terms of,
If you did require a notice, then I would think there needed to. That's the only reason I asked.
and it's very sort of intentionally vague in a way because the council are sometimes intentionally vague, in terms of, and council will say, please don't call my lawyer because I have to pay them by the hour. If you didn't, and some of the applicants, that's important. So that's why we figured that just making it clear that if council is involved, they get copies of everything. But beyond that, it's up to the applicant and their counsel to sort that out.
So recognizing again that there's a case pending before the Supreme Court right now that might provide further guidance on this point, and that Work Group 4 also has language similar to this. I'm wondering, would we get to the same thing under nature of proceedings if we said CCF proceedings are governed by these rules, except where explicitly provided otherwise, or words to that effect?
Bill, that makes sense to me. The question I had with A is whether it's just procedure or whether it's substantive as well. They're trying to carve out the, substantive criminal law concepts do not apply here, substantive. And I don't know. And that may be.
If that gets more to the point.
And I agree with removing the Latin if we can.
Well, and then I'm thinking, instead of just simply saying it's not A or B, it's its own thing, just saying it's its own thing in more precise words. That nature CCF proceedings are governed by these rules unless explicitly stated otherwise.
Justice Montgomery, should we ask to put a note so that we mirror that in our working group or no?
Yeah, well, and again, like I said, we've got a case in front of us that may provide some guidance on this too going forward that might require us to take another look. So, put a pen in it for now.
I agree. I think it makes sense to be consistent with Rule 48.
I guess the question would then become, does it matter to whether it specifically says neither civil nor criminal? Because it's pretty bland to just say they're governed by these rules. That's if we're meaning to say they're governed by these rules, so they're not civil or criminal. It doesn't really say that if we leave out civil or criminal. So if the intent is to, again, without knowing what the case might cast light on,
Well, then maybe combining both points that CCF proceedings are neither civil nor criminal, but are governed by these rules unless explicitly stated otherwise.
yeah, I mean, that would retain the distinction that, don't come in and say the civil rules apply to the criminal, because they clearly do not, whereas if it just says they're governed by these rules, I think that would still leave it open for somebody to come and say, well, they are, but you also incorporate other rules. So
Well, striking that language would suggest we were trying to say that they do apply.
Judge Thumma had a great,
consistency is important.
and Judge Thumma's point is interesting. Is because in the discipline rule, it says disciplinary and disability proceedings are neither civil nor criminal, but are sui generis. And this, the rule 34.16, as it's now designated, CCF proceedings are neither civil nor criminal, but are sui generis. Is it just the procedural aspect, or is that saying, is that limiting the substantive? That's an interesting aspect I hadn't really thought about
Well,
for these particular rules.
Question based on ignorance, not knowledge, but I just wondered if that was the intention here, just to get rid of those entire fields of law and look at these things uniquely. And if it is, we need to account for that, or we'd be making an unintentional change.
I had a quick question just on the subpoenas part. And not being familiar with how this process works, but do the subpoenas, once issued by the chair, then have to be served formally, like they would be under Rule 45, where you're looking at service and then I think an affidavit of service is then supposed to be filed, or is it? Because I thought if we referred to Rule 45, then you would invoke all those provisions about service of the subpoena. John's looking at me shaking. Yes, that should be the intention, but I just don't know if that's what happens in reality.
No, please strike it.
Well,
And I would say we don't do, it's a unique animal in discipline. So again, I think we need to mirror each other. So we don't get into.
so we don't want. Is here, but then would you want something that says how they're to be served? If they're not to be served in accordance with Rule 45, it just says the chair can issue them, but then what are they? What do you do with them? I mean, can I email them?
I think they're probably intentionally vague for the
Okay.
same reasons as.
And it so rarely happens.
Okay, then I'll let it go. Just
This is clarification. It says rare. Have you ever issued any subpoenas?
It's rare.
It's very rare.
Yeah.
I think Ed might have over the years, but only a few times.
David.
I haven't been, and I was an investigator, yes, we have for.
Does that have any enforceable law?
Where we get into trouble is when we go out of state. So.
I think for these rules, it's perhaps similar to subpoenas and arbitrations, that it has the force of law only if it has to be taken. And for most people, they just honor the subpoenas or they use them for discovery. But if it really becomes contentious, it's going to have to go to a judge to enforce it.
All right, we have David Rosenbaum and Judge Kalman have their hands up.
Judge, your hand was up first.
Thank you. This is just, I'd like to go back to representation by counsel. And I'm a little bit concerned that putting in the right to be represented by counsel instead of a may give people a misimpression they have the right to appointed counsel. So I'm just wondering if there's a way we might rework that wording. I thought may was fine. And I think it avoids the problem. But if we put has the right to, I almost feel like we need to put in some kind of proviso that's still at their own expense.
Well, you can say counsel may represent an applicant in any proceeding, and then that takes the compulsion out. I mean, there's, I think that would be interpreted as, if you have counsel may represent the person.
Or you could just say at no expense to the government, at their own expense.
Or retain.
Retained.
I don't think that we even need to add in at their own expense if we have a may in there. I thought that was fine. Either the applicant may be represented by counsel, which I think is fine because it's focusing. I know it sounds like passive voice, but the applicant is really the focus of the issue anyway. So saying may be represented by counsel doesn't really give me any concerns about passive voice.
I'm concerned that it suggests that the committee can say, well, no, you're not going to be represented by counsel.
I agree with
Maybe
you,
you
John.
do, maybe you don't.
You could say
That's how we feel
the
today.
applicant may choose to be represented.
That
Yeah,
works.
like that.
You know, if we say retain, as somebody suggested, that eliminates any suggestion that it'll be provided. And so the applicant may retain counsel.
May retain counsel to represent them in any proceedings.
Isn't that implicit?
I mean, I thought it was implicit with the may, but if people are concerned about it and concerned that there may be any interpretation that might say that the committee could say they can't be represented, I think that knocks that out. If you say that I can retain counsel to advise me in advance of proceedings, but if we need to be explicit that I have the right to have counsel represent me at proceedings, then we should be explicit. I'm fine. And I do think putting in may retain does take away the problem of making it look like they have a right to appointed counsel.
And it's active voice.
And it's active voice.
Yeah, I'm not sure if the convention is used them, or is it just him or her?
You could change it to applicants, plural.
Or
So I have a question about using that term retain, and I've never been retained as counsel, so there's where this question's coming from. By using that term, when we have just said that it's intentional, that we're not requiring a notice because the applicant may not want counsel to be intimately involved in all of the workings for cost purposes. When we start using the term like retain, does that then potentially signal to the attorney who is being retained that they could have some sort of malpractice issue if they aren't intimately driving the truck every way with character and fitness?
I'm not worried about that. That's an obligation on the attorney to clearly delineate what your responsibility is in your engagement letter. Because I can be retained just to provide information to a client and not file the subsequent complaint, et cetera. So that's incumbent upon the counsel. I don't think that's something this work group should be working on.
I just think the may that we first had, may represent, gets you there. I don't know why we're making this potentially more cumbersome.
So we're looking back to what Amy said.
Well, I'm the novice in this regard.
There actually is a problem with, we often use the word retainer, not a retainer, it's a fee.
I really think that it was fine the way it was. I think that passive voice should not always be rejected when it keeps the focus on the correct person who is the applicant. And I think that everything we're adding is just leading to further confusion.
So I don't really see the committee ever saying, you know, we have the discretion to tell you you can't be represented. And I certainly would never want to make that argument to the Supreme Court.
I was going to ask you or Ed whether or anyone else who's been involved in the process or represented anyone has anyone ever encountered this issue?
No, and I can't imagine it. If counsel came and said we're representing the applicant, they would be allowed to do
Ed
it.
has his hand raised.
Ed.
Yeah, I don't want to squelch the conversation, but in the, I don't know, 14 years I've been on the committee, whatever it is, none of this has ever been an issue, ever.
Well, if you just add the word choose, may choose to be represented by council, then it really is clear that the committee is not your choice. To Amy's point, George Orwell in his rules for writing said always prefer the active. And then he has several other rules, but his last rule is violate any of these rules if it causes you to do something abominable. And I think we should go back and just put may, use the passive voice here.
David, were you wanting to say something else? We see that your hand's still raised. Yeah.
Yeah, so my hand was raised before this discussion started. There were a couple instances where we're using passive voice. I don't think we need to. I think we added one in A, and then there's in D where are governed by, and then in D the rules are applicable. Why don't we just say that these rules govern? Make it active. And if we want to say and not other rules, then we say, not civil or criminal. And by the way, I was confused by the whole discussion. I mean, I don't know, getting to Sam's point, like what are we guarding against here? Is this a constitutional right, a due process right that might differ if it were a civil or criminal proceeding? I don't know. But I defer to others on that, but I think it should be, let's just go back to our founding principles on this task force, which is restyling. I think this is simpler than active voice. And then I don't know that we need the word explicitly. Yeah, that seems to me these are simple, short, understandable statements. Again, I don't know what the second sentence is intended to guard against, but other people think it's important. So, and it's better than sui generis. And then in D, talking about the deposition rules, again, we use the passive phrase are applicable. Why don't we just say the rules of civil procedure governing depositions apply? And I know that's what the current rule says, but it's kind of vague, like which rules of civil procedure governing depositions. It's not just 30, right? There's the rule on how to use them in court, and I don't think that rule applies, right? Rule 32, using depositions in court proceedings, and then Rule 31, depositions by written questions. I don't think, do we really, I mean, is the intent here under the current rule that Rule 30 applies except for 1 and 2, or A1 and 2?
Question. We want to keep this vague because as we get further in the rule, as you know, you don't have to follow the rules of evidence. It's not grounds for an appeal or what have you. So I think this is done vague on purpose. I would like to keep it that way in mind. So
the idea is that in the rare case, there might be a need for subpoenas or depositions, but it's very, very rare.
And it goes back to this whole purpose of this is like a limited jurisdiction court, so to speak. So it's not civil, it's not criminal. we don't necessarily have to follow the rules of evidence. We have rules, so I think this kind of falls into that category, and I like to keep it there.
Yes, it seems to provide general guiding principles about how we're going to handle the way that the litigation or the hearing is conducted, and to allow flexibility, ultimately with the view that due process must be afforded to participants, but there's a lot of flexibility to informally work that out and observe the fundamental rights involved.
And it says later, it expressly says later on that failure to follow rules of evidence and other rules are not grounds to overturn a decision.
So instead of governing, it's really on how depositions are taken, isn't it? If we could use like taken instead of governing, because you want some set of rules. If you're all sitting there, like how you act, right? That's really what it's getting at, is how you object, who goes first.
And the current rule says all of the rules of civil procedure authorizing, relating to, and governing depositions in civil proceedings within and outside the state are applicable to depositions in connections with investigations and hearings. That's currently there. I'm not saying it should be there.
How many depositions we do.
That seems broad, like really broad, like all of the rules of civil procedure. So
that's where John started by carving something out. You don't really mean what the current rule says.
yes,
So that's the discussion now. It's for everybody's sake, we're trying to keep this guardrail, not specifics as anybody has.
I think there's a difference between taking depositions and using them, right? Yeah, as for a hearing.
I think sounds like it would be for taking, not the use.
Yeah, correct. That's what I
Right?
would think. Yeah.
Like you guys want flexibility in how they may be used, but the taking of them.
You want to strike governing, put taking, rules of civil procedure for taking depositions.
So that's Rule 30. Why not just say Rule 30 applies?
There's
That's
something.
the only rule that deals with taking. 31 is written interrogatories, 32 is use.
John had a point that Rule 30 has some stuff that we wouldn't want to incorporate.
And that's the except for
Yes.
portion that has been added here.
So if for some reason you wanted to address outside the state thing, the way that we do it in the disciplinary rules is under Rule 47. It's H5, and it's labeled deposition in foreign jurisdiction. It just describes what can satisfy that happening, so that you wouldn't have this odd language. If we're going to incorporate the rules 30, you may want to. I'm saying it's great language. Whatever. Sorry?
I mean, in a civil proceeding, if in an Arizona case, I want to take a deposition in New Mexico, I follow the New Mexico rule so I can take that deposition. They may have the interstate rule, which is our rule 45.1, or they may have something else. We don't get to dictate how I can notice and take that deposition out of state. Somebody comes to Arizona to take a deposition to support a case proceeding elsewhere, then our rule 45.1 applies. So I don't know what outside the state means, but it can't be that Rule 30 applies because it doesn't. We don't get to tell New Mexico how depositions can be noticed in their state, how a subpoena can be issued to compel attendance in their state.
Part of the main reason to include it is to say we can do it. It's very rare. It's likely, I can't remember depositions ever occurring. And so, and this has a lot of more detail perhaps than we need, but I'm wondering if the idea is to say we can do it, but we aren't necessarily incorporating every subsidiary rule. And the rules give enormous discretion to the chair and the committee when it comes to procedures. So maybe we could just say something like, subject to limitations approved by the chair, the rules of civil procedure governing depositions apply. You know, it sort of then sets a counsel or an applicant to say, this is what we want. We want this rule or that rule, here are limitations. And then the chair, in approving a deposition, says, this is what you can do. And then it leaves it open for debate. But again, it's going to have to be sort of reasonable. Because again, I'm always thinking, okay, how can we as a committee justify what we do to the Supreme Court if somebody takes a petition for review? And again, we try to not do gotchas. So it says you can do depositions, but it's subject to limitations, or maybe that's not the right word, but subject to conditions imposed by the chair or approved by the chair.
How would the attorney representing the applicant know what those are?
They would have to propose them because, you know, they would say, okay, we want depositions. We know the rules don't completely apply, but this is what we want them to be. It would be very much a case by case.
Pat, is that how it happens now? In other words, if you're representing a respondent or petitioner applicant, do you just notice a deposition, or do you need to go to the chair and say, hey, we would like to?
I've never seen it happen. Ed might have seen it happen, but I think that's the way it would happen, that somebody would propose a subpoena for a deposition.
Well, that's consistent with the subpoena provision, although you don't always need a subpoena to take a deposition. So this makes sense. It puts, if that's the intention and the practice.
I know I do AAA arbitrations, and that's how it happens there. You know, they propose depositions as part of discovery, and here's how we're going to do them. And then the chair or the arbitrator agrees or not.
The other question I had is if we really are focusing here in this first sentence for how the depositions are taken as opposed to how they're used or otherwise, does it make sense to end that sentence in connection with CCF proceedings? Because it's not investigations and hearings. It's sort of, hey, under this whole umbrella, here's how you need to seek to take the deposition.
Could you just put a period after apply? Why do you need that additional language?
Oh, yeah.
It's already under this particular rule.
Yeah, I like that better.
What if he didn't say anything about depositions? What if he just talked about subpoenas? Why, you say it's very rare. In fact, you say it's not even occurred.
I haven't seen it.
Do you need to say anything?
Well, I think it should be there if that ability exists. And the rare possibility that it happens, I think it needs to explicitly say that it can happen. Because if I'm representing and I don't know that there's even the ability to do a deposition.
Okay, what if you just said may issue subpoenas and conduct authorized depositions? And not get into it, because that's really what you're doing, putting a lot of words in to say, we're not telling you what the rules are. You got to individualize. Why say it?
But this establishes that the universe of rules that are going to govern the conduct of the type of discovery are going to be the rules of civil procedure that pertain to that jurisdiction. That's your universe. And then you figure out from within that, if you strike that, then that suggests that it's sole discretion to the chair to make up any rules he or she wants. But here, it's the rules of civil procedure, and the within or outside of the state, that pertains to the rules that are applying to where that deposition is taken, which somebody made the point. You know, the rules of procedure in New Mexico, to the extent they vary from Arizona, if the deposition is being taken there, that's your starting point. That's the universe of rules that you must comply with at the discretion of the chair.
Yeah, I think we should make a mention that you can take depositions and then what rule set you would use, take them, because someone could get in there and say, well, I'm taking a deposition, but no one else can ask questions. Only I can, because it's my deposition. So you want to, you know, you could get situations like that, I think.
Just as an integral suggestion, instead of saying approved by the CFF chair, to say subject to conditions, the CFF chair approves. Saves a couple of words.
I feel like the thereof now. Let's move to 34.17 if nobody else has any discussion at all. We'll be reading the first time, so. What's that?
I told Tom, this rule's been screaming his name for years. So very exciting to be here right now.
Many people have screamed about this rule.
Yeah.
This one has, there's a lot of substance here, so we tried not to change much. So the working group, we restyled without making substantive change and certainly any input about it. So this has a lot of provisions that are, I won't say vague, but they're very broad in terms of the mission of the committee. And ultimately that leads to, you know, the factors the Supreme Court will consider admission. So the burden of proof is an always important one in A, and restyled to say the committee on, let's see, character and fitness to match the rest of the rule. The burden, applicant has a burden of proving good moral character and fitness to practice law by clear and convincing evidence. And it's an important one because, and it sort of highlights that it's not civil, it's not criminal. Clear and convincing is a higher burden. And this comes into play a lot, and particularly in the context of the difference between discipline and admission, that the applicant has the burden. Whereas, you know, for discipline, often the bar will have the burden. So this is an important factor, and we do get applicants argue about this and what it means.
I think you start with 2 points.
Yes.
By clear and convincing evidence is modifying the word proving. I would insert that phrase right after the word proving. So it says burden of proving by clear and convincing evidence, good moral character.
Okay. That makes sense. And we'll get down to the presumption later, but it certainly relates to the burden of proof. So D is factors, determining the character and fitness. Take into account the relevant traits and characteristics. I mean, this becomes part of the analysis of what we do, also ultimately the findings that might go to the Supreme Court and the things that relate to conditional admission.
And it's saying of an applicant, they can determine the applicant. And that's it. With the in determining the applicant's character and fitness, strike the words of.
Try to tie, use B with the parentheticals to then tie it to the next subsection. Have their own sort of separate analysis. That's what the rule's been harder to read because those have been divided. So that helps to sort of say you have to do all these things. It's not just one or the other. C, relevant traits and characteristics. This is the one where Aaron might have, there's a note there in terms of include the comment is under the current rule. The applicant must demonstrate current and past possession of the following traits.
Another, just to avoid having to say these traits and characteristics twice, I would suggest after the first following traits and characteristics, have a comma, strike the semicolon, and then insert the word with. It says a significant deficiency in one or more of them, constituting a basis for denying. Well,
Want to keep the may, so it doesn't sound so mandatory.
I wondered if you want to put that concept after you list the 5 things. You have to consider these, and then you say at the end, oh, by the way, a significant deficiency in one or more is a basis for denial of admission. Because that first text really combines 2 different things.
Can you have a standalone sentence like that after that list? Does that work?
That's what I would propose. Whether that's consistent with what we've been doing, I don't know, but that makes it clear.
Get rid of say these traits and characteristics twice.
Right. No, I'd use the language, John, that you proposed, but just plunk it right after 5.
Yeah, that you're going to have a separate sentence. It does create problems if you want to cite to it. You have these angling provisions at the end.
Sure. And what I didn't know is maybe that's a separate. That's D. Could that become D?
Yeah. That would address that. And I think you need to put back in traits and characteristics.
Yeah. And maybe that's a bridge too far, but I think it makes it cleaner to what you're looking at.
Clarity is more important than eloquence.
Would be of these traits?
Yeah, I think so.
You still say basis for denying admission. That's at least say the one word.
Yeah. Yeah. Yeah.
Black.
Right.
Lack thereof.
Yeah.
Oh, black.
I think to mirror, we need to put relevant in there, but lack of relevant traits and characters.
One thing the working group talked about, there's a comment to the current rule. So it's not incorporated in the rule, but it says the investigation conducted by the Committee on Character Defense should be thorough in every respect and should be concluded expeditiously. Should be recognized that information may be developed in the course of the investigation that is not germane to the question of licensure and should be disregarded by the committee. Conduct of an applicant that is merely socially unacceptable for the exercise of constitutionally protected rights is not to be considered relevant to an applicant's character or fitness to practice law. I mean, that's a comment which I couldn't quite figure out what to do with.
It seems like that last sentence could actually fit in with D though. So there's a whole lot of stuff you said at the beginning, which I understand, but I think that's instructive to you. But the last sentence that you stated seems like that maybe should be added.
But it talks about socially unacceptable is not, but it was included as a comment, not as part of the rule. So what effect does that have? Is it if we leave the comment out, is that a substantive change? Probably not. But it doesn't have a date on when the comment was put in there, but it's sometime.
I'd say that as restyling, there's been an effort made recently for part of the comment. Put it in the rule. This is frustration of rule right. People have the comment to explain what the rule means. No, that's not. It's important enough. It should come rule. But I being in a comment, I think initially the way that it's worked, it's intended to have equal dignity to be taken seriously in interpreting the comment. So that's a substantive component to it. I put it in the rule.
Yeah, the first part was pretty much procedural, do it expeditiously, but that last sentence was right in there.
Veronica added it, so that's what it would look like.
We relied on that more than deposition.
And we've had applicants who've, engaged in protests and all sorts of other things that are, look at case law even back into the 60s and protest, and it's what's the line between acceptable, civil disobedience, it's criminal. It's hard to draw sometimes. So
We get asked about that when we go to law school. Yeah.
So adding that would seem to make sense into the substance, into the rule itself, as opposed to a comment.
It is not to be considered is a long phrase. Don't we mean is not relevant?
Irrelevant.
Is irrelevant.
Is irrelevant. Yeah.
Is there ever a time where merely socially unacceptable due to volume is considered? I mean, it reads as though it's isolated. It reads to me that way. I'm just curious if you're blocking yourself out of something that it's like, yeah, you did this thing that's considered socially unacceptable one time, not an issue. 100 times, maybe a different issue. I'm just curious if it happens that way.
And I'm sure it would depend on the continuum of one time maybe socially unacceptable, but the 100th time becomes intentional and harassment or something. So yeah.
Serial disruptor. Where this usually goes sideways is that the event, a crime is committed. That's usually how it's addressed. So, but yes, if they're a serial disruptor, their sole purpose. Well, honestly, what happens at my experience over the last 10 years is eventually a crime happens and then we address the crime. I would, like I said, it's the only thing. What applicants, like I took my kid brother to a protest. I was like, that's awesome. That family bonding, that sibling. Did you commit a crime while you were there? No. Hey, we're good.
What about in regard to mental health? Because we can't ask about mental health anymore, but the way you deal with it is conduct. And so wouldn't that fall into socially unacceptable conduct? Couldn't consider it. What would you do with people who are schizophrenic and acting in a socially unacceptable way? You see that behavior.
Okay. It's socially unacceptable behavior based on mental health.
Can't ask about mental health anymore. The way you deal with it is behavior. It's usually socially unacceptable, or you wouldn't be asking about it. So if you put this in, I don't know how you're going to deal with the mentally ill applicant.
Maybe socially unacceptable is just too vague or too broad because murder is socially unacceptable. You know what I mean? Like maybe.
Depends on who you mean.
That's why
Not merely.
it's okay to be a little bit vague, but maybe you should think about what that statement's really trying to get at. Like, is it trying to get at what we're really concerned about are things that are relevant to the practice of law, not just relevant to your personality or something?
E10 addresses David's issue. So other relevant conduct, and it has conduct indicating mental or emotional instability, impairing the ability to perform functions of an attorney. So I think E10 and the other section, that doesn't address your issue, Professor, but I think Dave's, I think, concern is addressed in E10.
Is this sentence, is this new subpart D the right place for this sentence? Because D is discussing just the 5 traits and characteristics in C. And I think this sentence deals with those plus other relevant conduct in E, which would now be F. So maybe this should be some other standalone subpart and not a modification of D, which is discussing just honesty, trustworthiness, diligence, reliability, etc.
You put it in the evaluation of criminal history and other relevant conduct.
Yeah.
That the committee weighs. Application.
Yeah, I think that makes more sense putting it there.
I guess my point is this is an overriding theme that could apply to any of these subsections. So maybe it should just be its own new subsection.
Would you want to put it more to the beginning?
But I think, well, Mary Ann's point about what is condition of D, it becomes G, I guess.
Yeah.
But it's evaluation of criminal history. Or, well, E is other relevant conduct, and we're saying this is irrelevant. So, yeah, but in terms of as part of the evaluation of criminal history or other relevant conduct, you know, that sentence just at the very end of that, sort of after 11, maybe, but not a separate number. You know, maybe that would be a better place for it.
Or it could go up under.
I guess I'm a little puzzled by what constitutes socially unacceptable conduct. I can understand the constitutional. I know there's been, as long as I've been a lawyer, we've always been plagued by yellers, screamers, that are bully raggers, and they can get disciplined for being. That is certainly socially unacceptable behavior, and I would think we would want to consider this guy's fault.
Is it more of like socially awkward or no? I don't know. I don't know what the intent is, but
they're gay. Is that what they're driving at? Or I don't understand what.
Or maybe historically, it's probably true.
Yeah, no, yeah.
Actually, I think the issue is, one is, you can talk about constitutional rights, it's a little bit objective. Socially unacceptable is very subjective. Maybe that shouldn't be in there at all. You should look at the conduct that occurs, not what somebody's view of what is or isn't socially acceptable.
Be a separate hearing.
It could be separate. Somebody could define it. But I mean, I think, I don't see what good it really does there, the term. Why not just take it out? leave it to objective behaviors or constitutionally protected actions.
Or one other, if we keep that language, maybe under B, it goes up,
Factors.
under, because what that language is saying is this, it isn't a factor.
Well, do you need that phrase? We're having trouble defining what socially unacceptable is. Why not just go to the constitutionally protected rights? And if you think about that, maybe that should actually be at the start of the next section related to crimes. Because if you get convicted of a crime, but it's constitutionally protected issues, that's your issue.
That's right.
It wouldn't be a crime if it was constitutionally protected. So I think this is dealing with something else.
Suppose you could have a criminal conviction and you still maintain that it was constitutionally protected, and that would be what the committee would consider. So you committed this crime and it wasn't for the purpose of, robbing from a Circle K, but it was some other purpose. Yes,
But you lost, right? Presumably you would have raised that as a defense.
Well, maybe you did, maybe you didn't. Depends on the circumstance.
So the way that I read this is like, think of OnlyFans. There may be some members on the committee that say that that is socially unacceptable. That is not the character and fitness of an attorney if they engage in that behavior. Approved very easily could. Somebody, I hate to use the word prude, but somebody could. This is saying you can't. You can't consider that. So I think I like having that in there saying, hey, that stuff is not relevant, because as a teacher, it is. You will get fired as a teacher if you're on there. As an attorney, it doesn't apply to us. And I think this is what allows that to be clarified.
Well, what is?
Porn. The easiest way to describe it is engaging in pornographic videos. So as a teacher, you cannot engage in pornographic videos. You will be terminated. It happens all the time. There is no prohibition of an attorney, and I think this clarifies that. Not saying that we condone it or suggest it or endorse it, but that I think is, at least in certain circles, is socially unacceptable behavior. It is constitutionally protected, but when we're talking about somebody's moral character and their fitness, that could become an issue. And I think this clearly says you don't get to think about things like that.
And I think that's maybe what it's saying, that this is one of those times where it's merely socially unacceptable is intended to not be defined, because it's saying to the committee that if you can't define bad conduct based on these other rules, then don't take it into account. We can't just say, well, this applicant sort of bugs me,
Yeah, a guiding light.
Yeah.
What I actually say to staff, you don't have to like them to license them. You have to stick to the parameters of the rule. And is there another area of the rule that this applicant isn't meeting the program? So that's kind of how I would apply it.
If we have conduct that violates these other things, then it's not conduct that's merely socially unacceptable. It violates other things. So if it just it just bothers us, then that tells the committee to not, it's irrelevant. So we have to articulate things better if we're going to find it disqualifying.
Ed.
I can think of at least two instances off the top of my head, cases that I think both Pat and I were involved in, where there was a fair amount of what I would describe as socially unacceptable behavior, but it was also coupled with criminal conduct. And the socially unacceptable behavior was certainly considered as a part of the overall evaluation of the applicant. Did it define our recommendation of denial? No, but it was a part of it. I know that doesn't really aid the discussion, but I wanted to note that for you.
And let's give an example. Let's say somebody chains themselves to a fence at the nuclear plant, and they're engaging in civil disobedience, one of which is they accept the conviction. Yes, I did it, and I'm making a point here. Is that the person then that has engaged in socially unacceptable behavior?
That's a crime.
I think it might be a little bit easier on that one, Bob, where you can say that you're convicted of a crime.
So then you're back in the thing of
The only
By
thing
clear and convincing evidence of the circumstances, you should still be admitted.
I think it would be up to you as the applicant to demonstrate that even though that happened, it doesn't preclude you from being admitted.
So you're back in the provision, the next provision. So you're not convicted of socially unacceptable behavior that you should be disbarred for engaging in civil disobedience. That
Disbarred or admitted?
Well, I beg your pardon, admitted.
You can be way more socially unacceptable and still maintain your practice versus trying to get admitted in the first place. Present company.
No, I just wonder, I just don't like vague terms like that, which are subjective and so circumstance specific.
Is there an area that specifically gives the committee the ability to consider injunctions against harassment and orders of protection?
Taxation, yes, we have abuse.
Violation of court order.
Well, that's still a
Only
violation.
if you violate it.
Yeah.
You were the subject of one, right? The applicant was the subject of an injunction against harassment.
If they were the ones that their activities were
We have
considered
a piece of legal process.
harassing,
Well,
that wouldn't fall.
So
So my concern, if those aren't, they shouldn't be considered, but I would think they should. And so that would be my concern. If you don't have someplace else where something like IHs are considered, I would think they would then fall under the socially unacceptable. That's the the injunctions against harassment, I think, is more close to just socially unacceptable as opposed to order protection, where in theory there's been some semi-volatile issue.
Does it seem like that should just be another one added to other relevant conduct? I mean, that would be a consistent or pervasive violation of rights of others.
I think with this language, it needs to be somewhere, so I have another hand.
So I think what Judge Irvin said about the word merely being the modifier is an important thing to emphasize again, because I think maybe that takes us out of some of this worry of the vagueness of socially unacceptable. It's like just on its own, socially unacceptable with no other bearing on the practice of law is what I kind of read that merely to be imparting. So thinking of it in that lens, I feel less concerned about whether it's a little bit open-ended. And I think as we noted before, it's good to be a little bit open-ended in some of these rules because we want to give the committee discretion, right? A lot of discretion in determining the good character, in evaluating character and fitness. So I don't know if that helps us move the discussion
I think
along.
that's right, because I think, Pat, as you noted, that is intended to capture behavior, conduct that we find distasteful. It seems off-putting, maybe seems unprofessional, in a vacuum. But if you can't marry the conduct to a deficiency in one of these traits or characteristics, and it doesn't fall under any of the prescribed conduct, then you can't hold it against it. I mean, it seems pretty clear in application. It's vague, but it's not when you think about the function that it's serving.
Right. That in the context and the word merely, I think accomplished the purpose enough for this. I still think there's an issue of whether it belongs under D because it deals with conduct rather than traits and characteristics, but that's a separate issue.
can it go under the other relevant conduct as another subparagraph?
Seems to make more sense to me.
Anne had a good idea of putting in B.
I think it fits in D. Right? Because,
yeah.
Because then that pulls it into all three of the factors.
Because the comment seems to apply to the entire rule, the entirety of the rule. So it needs to, the part of it's going in the text, it needs to serve that function clearly within. Yeah, I like that.
Where that was
in our work group, we had this discussion, and what we came to after 3 hours was, let's see what the task force did. Then we gave this conversation, so appreciate that. If you were able to do that for us, I think this is good.
And we recognize that was a socially unacceptable way of approaching it.
What if somebody was never criminally convicted of anything, but like they had, 3 civil lawsuits filed against them for sexual misconduct in the workplace and they settled them? Can that be looked at, or is that no? Is that
E1, other relevant conduct, unlawful conduct not resulting in a conviction for a crime.
what if it's not not there was never a criminal case, the person.
Yeah, this is just unlawful conduct. So if you were harassing someone, that's unlawful in the workplace, right?
Settled.
Accusations.
So you said I
They were
didn't
just
admit it was allegations, yes, so I didn't admit, a lot of people say, oh, I settled because confidential settlement, but if it was like, let's say we see some rises to the level of like some professional athletes we see or whatever, and they vehemently deny it, it's never criminal charges, but a big civil.
So how do you deal with where there's smoke, there's fire situation?
I guess so, and I don't want to be dramatic, like maybe this never comes up,
No,
but like.
it does.
Okay, like that someone's never been criminally, but there's a pattern of civil
Concerning behavior.
concerning.
Yeah, there's a difference, as we'll see in D, there's a presumption if you've been convicted of certain crimes. But the committee's ability to look at any unlawful conduct is there. And we do, including civil.
So what if it?
Yeah.
But you could have 40 arrests supported by probable cause, which never culminated in prosecution. And that's a pattern that you would want to pay attention to and delve more deeply into. And it happens. You can have somebody with one conviction and you look and they've got 30 arrests and many of those supported by probable cause, but the charges are ultimately just dismissed so that it never culminates in anything. But you got a long record of alleged criminal conduct.
And that would be litigated.
Okay, sorry, I was thinking of not, you were never, like.
Well, it's just that you get accused of a bunch of things and you always settle them right away.
Yes.
You pay off the complaining witness. That would be litigated for the committee, right? Someone would write you a letter or something, say, hey, this guy shouldn't be a lawyer.
Or it's disclosed because the question asked, have you ever been arrested? And it asks for civil.
Like these, like.
So that would fall under negligent or disregarded ethical or professional obligations to your scenario. So that's the next section of the rule. So
That's in.
yeah, that's how we would handle workplace harassment. That's how I would do it.
And where was that at?
What you're saying is many settlements and no admission of guilt.
E8.
He still pays $50,000, but he makes no admission of guilt.
Yes.
It's potential, ethic, professional.
But we ask them about those things. Yeah.
Oh, so that would fall under, is it?
Under the
E8.
revised numbering
In the paper, it's E8.
8.
Okay.
You also have 4, misconduct in employment. Could fall there.
Yeah, I just didn't know if the person said like, no, I'm not admitting any, they settle and say.
That's mitigated by the fact that these people have so much experience in the practice of law before they ever come.
And there's lots.
All those are, that was an education.
And especially the admission on motion where they've been practicing a while, there are certain areas of practice like family law where you get a lot of complaints.
Yeah.
And so if the bar in the other state has dismissed them summarily, well, they can have a number of complaints and it's not disqualified, but we'll look at them to see if they've gone further, then it could be a problem. But there are some areas of practice that just lead to lots of issues, and we see those. But
We go back to B as it's restyled now. I had a question on the new language and I just wanted to. So that B has 3 buckets of factors, right? Relevant traits and characteristics, conviction of a crime and other conduct, and other relevant conduct. When we added that in, and that's really a question, Pat, to you and to John's point, we just limit that to character and fitness. the conduct that's socially acceptable or constitutional protected rights, is it just for that one bucket, or is it not a relevant factor for all three? And I think it's all three. We don't care about criminal convictions because that'll be handled separately. We might under other relevant conduct, right? But so I wonder if an applicant's conduct that is merely socially unacceptable or the exercise of constitutionally protected rights is not a relevant factor or something like that, because this is the factors. There are three buckets of factors. And right now we've accounted for one of those only, not the other two. And if I remember right, the comment was, this applies across the board for the entire rule. Is that
The current comment is at the end of the whole rule.
right? And so I wonder, because right now, is not a relevant factor or something like that to make sure it fits. It applies to all three of those buckets.
And you wanted to apply.
Yeah, and I'm not worried about criminal convictions because that'll kind of do its own work. Other relevant conduct, it might. And so we're not saying, hey, socially unacceptable conduct, you can't consider for relevant traits and characteristics, but you can consider for other relevant conduct. I don't think that's what we're saying at all. And this removes that ambiguity.
We haven't skipped over D yet, have we?
No, I think we're about to get to that.
I have some questions for you.
Yeah, so we added D, so let's see, we've solved it already, we've jumped over that. But as I said, stuck with sort of the current factors other than changing the comments a little bit under now D, and I guess let's go back up to D. Again, just the list of the 5 factors there: honesty, trustworthiness, diligence, reliability. And this is sort of a catch-all. It allows us to look at a lot of different things, and ultimately that language comes from Supreme Court cases in terms of what the factors to look at. They are very vague, but that's what we have. So, and then moving down to more specific ones in now E, but D. So, and then conviction of a crime or other conduct. This is the one that the first one is a presumption that the court has adopted in the rule, rebuttable by clear and convincing evidence that the applicant's been convicted of a misdemeanor involving a serious crime or any felony. So this is important, for a number of reasons. One, it sets a pretty high bar for applicants who've been convicted of crime. It also then requires that to the extent we rebut the presumption, it has to have findings by the committee that then go to the court, which then has its own independent evaluation. And that's where that works. So
why the word of serious crime definition?
I don't know, is it reworded or just moved?
Oh, okay. That's a good thing. Serious crime means any crime.
Is that consistent with the future rule? We had the same came up in another rule.
Yeah, it came up in Rule 54.
Is it the same wording now?
Yeah, it is.
Okay.
I would point out this deprives the profession of the services of many jail lawyers who are.
They apply for admission, we'll take that into account.
So by the way, they all have great handwriting. It really is.
Okay. Very good. You had a question for me.
My question is, based on the new statutory sealing of records and all of that, how does that play into here? So if I'm from wherever my criminal conviction has been sealed, do I disclose that I've been convicted of a crime? And if I do, I think we probably should clarify that, because I'm told otherwise that my record's been sealed. There's almost nothing I have to disclose it for. So I think
I've been asked that specific question by clients.
I think but the application tells people that is, and I think it's consistent with the rule is that, being sealed, being expunged doesn't change this process, which is sui generis, as in terms of, it's not civil, it's not criminal, it's independent. So I mean, we try to be clear to people, but and I think we're trying to make the application as clear as possible that being sealed, being expunged, none of that absolves you from disclosure. So it's a factor, you know, if enough time's gone by and the original court expunges it, it's a factor, but it doesn't absolve you from disclosing.
Here's where this would come up now. There's limited expungement and there's a law. So people have these marijuana convictions, they're expunged under the new statute. Now, is that still for our consideration?
I think it's still for consideration, but you know, that it'll be given the weight if it's no longer illegal.
I think you might be able to make the argument, and unless the expungement statute or the sealing statute specifically states that, I think most of them will say it can't be used for any criminal process or for employment or something, but I don't think they go so far as to address applying for professional licensure certification. So absent that, I don't think.
I thought marijuana did. I thought the voter initiative did, like, because it even like impacted your office, our office.
That's Prop 207 in marijuana.
Right.
I was looking at the sealing statute, which has all those, and I think you're right, there's a lot of exceptions where they cannot, it says you can't use it, the subject to the arrest or conviction for employment, housing, financial, unless any of the following applies. If you do submit a fingerprint card, clearance card under Title 41, sealing wouldn't apply.
Okay.
I don't know if that's part of.
They don't.
Submitting.
They submit fingerprints, but not clearance card.
Okay.
It's different. So, but there is a statute, it's on my desk. It says if you're seeking licensure, it addresses sealing. I don't know it off the top of my head. My trustee assistant is currently Googling.
Well, there's, as I recall, there's two expungements. One are the marijuana, which are fairly recent. The other is a juvenile who's transferred to adult court and apply for expungement.
I think it's a destruction of records.
No, just an expungement. Everything else in Arizona is set-asides, which aren't the same effect as expungement.
Yeah, I guess the bottom line point would be that if character and fitness sought to inquire into something that is statute specifically provided for the exclusion of consideration, that's a different matter.
So the key issue, though, is they have to disclose, even though their conviction was expunged.
That doesn't seem to be squared with the marijuana statute. It says an individual whose record of arrest, charge, adjudication, conviction, or sentence is expunged pursuant to this section may state that the individual has never been arrested for, charged with, adjudicated, or convicted of, or sentenced for the crime that is the subject of the expungement. Ordering disclosure seems to be directly contrary to the statute.
Well, I think that provision was intended to allow individuals who were filling out an employment application to fairly and honestly indicate, no, I've never been convicted of a crime. I think that was the intent for that part. I'm just highlighting that if.
But this is what it says.
No, I understand, but it could be, you'd have to look at the other provisions to see whether or not there's a further exemption for licensure or certification.
This doesn't say, it doesn't have a further for license or adjudication, but this doesn't say for employment. It just says that they may state they've never been arrested for. I'm looking at the whole thing. It's ARS 36-2862.
And the self-represented applicant or the attorney that he retained on their behalf can make that argument.
Well, I mean, what's a bar application, but just employment?
Yeah. I don't see why we're carving out special exceptions that we don't want to apply to any other licensure or any other employer because we think that we're somehow distinctive.
Well, also, just out of curiosity, what about somebody who's had a conviction overturned? Do they have a duty to report their conviction and overturn?
Yeah, but they have to report arrest.
Yeah.
So they would explain that in their disclosure. I was arrested, I went to trial, I was convicted and then I. Yes.
And generally, what happens, the disclosure, you're expected as the applicant to disclose and explain. So often you'll see that, I'm disclosing these arrests, they were whatever, or no return, whatever it is. The problem is when the investigator finds something that wasn't disclosed, and then they ask the applicant about it, why didn't you disclose this?
Right.
And then there's a difference between, oh, there's this statute in Arizona that says it was expunged, I didn't have to, I'm trying to do the right thing. Versus another applicant who says, I don't have to disclose this, I don't think, but I am disclosing it anyway. And this application is all confidential, so there's lots of different ways. I'm disclosing these settlements that have non-disclosure agreements, and then they explain why that's there. So it becomes a back and forth when the investigator finds something that wasn't disclosed. Then it gets into some of those credibility issues. Right. Did you have a valid, you thought you were doing the right thing, or is this a gotcha? You were trying to you didn't think this would be found out, but we found it. So those become the character fitness.
And the rule we're talking about isn't the one that talks about disclosure. So I mean, just to talk, I mean, we're talking about the presumption. So it is a question, as Aaron says, when people say, I didn't think I had to, more often than not, we take them at their word, because we understand the confusion of it. And that's why I think the application tries to be really clear as much as we can now to say these things don't. But
I was just thinking, what about the guy who robs bank, never got caught? Is he supposed to disclose now in violation of the Fifth Amendment? Okay.
With Prop 207 though, and I'm not saying that the initiative wasn't extremely broad, and as you were saying, discussions about how it was, I mean, I think it was intentionally broad, but does it come in, like, have we looked at what the medical providers require, and because it's still a federal offense, that plays into it? I don't know. If you get expunged, I mean, you're not federally convicted, but it's still a Schedule I substance. That I don't know, like, I was just thinking that's how.
Well, the expungement is of a state conviction, right? Not of a federal conviction.
Yes, but here is just Google, it says what Prop 207 allows for the expungement of past marijuana related offenses. They generally must be disclosed to licensing boards until formally expunged by a court, which makes me feel like if they're expunged, you don't have to disclose them.
Says the clerk of court has to seal the record relating and can only release it to the individual's attorney or the individual. So if your investigator found it, then there's a whole different violation of the law because it can never be released. Like I remember we got orders and we actually had to change our database at the county attorney's office because we could never share that information, and that's subject to C1D, I think.
Charged convicted state. That still matter because it would be underlying unlawful conduct. Still unlawful federally. Right?
True. Yeah, it could be.
But if you're not arrested for it, you don't disclose it.
But if you were arrested, so say you were convicted here in Arizona, got an expungement, would you still have to disclose it because it's unlawful conduct federally?
Under the current process, they do. Under our current process. So they're saying it doesn't matter if they've been expunged.
Okay, but I think they're saying that it should matter. They're saying,
Don't point at me, I'm just saying that.
I'll just.
I mean, I think the plain reading says I get to say I was never arrested, point blank. So, and they can never get the information that shows that I was arrested. So I just think it puts the applicant in an odd position. I hated this law from the beginning. I opposed it from the get-go because it's state sanctioned deception. I mean, the state is telling you, you get to lie to employers, you get to lie to everybody instead of explaining and justifying. But there doesn't seem to be a carve out for professional licenses under the statute. So I think they get to lie to the state bar, and there's not a darn thing the state bar could do about it. That's my read of it.
Or at least ultimately, if they did say anything, be able to say, but it can't be considered because of that statute. So there's a distinction then too between what you're providing, your explanation for it, and what character and fitness might be authorized to do with it.
John, did you have a clear point?
Yeah, I've got all the picky points. But I was going to suggest that for subparts 1 and 2, we really benefit from having subheadings. One, have the subheading presumption. And for 2, would be the CF recommendation. So at least have this committees, I think, or is it on E1 and E2?
Going back to the expungement, maybe the policy should change, but that would be a substantive change here. But maybe it should be considered by character fitness. The very wrong policy has changed. Maybe it should be.
Also going to suggest that when you've got the definition of serious crime, that goes on for 5 lines. And it's only a lawyer can love it. I was going to suggest this is the way to cut out some words. So serious crime means any crime. If, adding the word if, necessary element, strike the words of which. Keep the comma. Keep the comma as determined by the crimes, statutory or common law elements. And you can strike of which, I'm sorry, common law definition of such crime, you can strike the words of such crime. And then that shortens that a little bit. In subpart 2, I was a little confused in statutory language. It says acting through or one of his panels must transmit to the court prior to admission. Isn't that obvious? They're not going to do it after. He said, I suggest striking the words prior to admission. And it says any recommendation for admission. I would say any recommendation for admitting or denying admission. Just as a point of clarification. And in subpart C under 2, instead of saying subsequently, use the word later.
Would there be any reason to transmit the denial if the applicant hasn't appealed? It's the point of this is if the panels, if CCF says, yeah, let them in, the Supreme Court has already said, no, we want to take a look at all of these that qualify here. Okay.
So if the recommendation is denial, nothing goes upstairs.
Not the applicant petition.
The use of the word serious crime for misdemeanors is a little bit confusing because serious crime is a statutorily defined term in criminal law that are really truly serious crimes. And usually serious crimes are felonies. So we're using serious crime to denote misdemeanors. Is there another way to say that? It just reads odd.
It mirrors discipline, just so you, if it matters.
Judge Metcalf, I agree with you. It confused me the first time I read it too. It seems like that has a very different connotation, particularly in the criminal law world, but I think it's multiple places. So if we had to change it, that might actually be a substantive change, and we'd have to make sure it's changed everywhere along the line.
And then we determine it includes like DUIs, misdemeanor DUIs.
But it's tied in with the presumption, which covers any felony conviction anyway. So serious crime really is things that aren't a felony conviction here. So
What's the old cream and falsity?
that
Well, it's kind of defined those old term cream and falsity, crimes related to falsity or bad character, moral turpitude. Rule of evidence 609. I don't like the term serious crime either.
So D covers or what's conviction of a crime or other conduct, and then moving on to sort of other relevant conduct or list. Also sets the criteria for when to investigate other things, and this important in terms of the staff reviewing as well, because if the staff sees any of these things, then it gets referred out to one of the committee members to look at. So.
This is the point we were talking about earlier about injunctions against harassment or orders of protection. If you've had one served on you and you're applying for the bar, this doesn't seem to suggest that you have to disclose that, although that is something that people would want to know. Or is it covered under?
Yeah, I think this is sort of for the evaluation as opposed to the disclosure. The disclosure comes in the application, which is very, very broad. And then the next section, evaluation of criminal history and other relevant conduct, sort of sets the criteria for the committee as to weighing. This is, I mean, as time goes on, the courts ask committee on occasion to go into these more detail, to tie our finding more to these factors, which is helpful from the committee's point of view too, because it gives us a guideline during a hearing. You know, the vast majority of applicants, it's not really relevant. You know, most of them, even if they have one issue, it's weighing and balancing is not that complicated. With some it is. So this list comes certainly from the rule, but it's also from case law. There is a guidance for how you weigh and balance how it goes.
Yeah, I can picky things
Sure.
on evaluation of criminal history. The last line at the introductory sentence, prior conduct, probably should be past conduct. Prior is a word that only police officers and lawyers use. One refers to level of sophistication and time of, I think it would be better to say when the conduct occurs. Part 4 says the seriousness of conduct. I guess the conduct's seriousness. Saves a few words. Again, a 5 refers to responsibilities. Then the conduct occurred, is that saying at the time of the conduct. Part 7, say the conduct's cumulative effect instead of the cumulative effect of the conduct. And then in part 11, materiality, the applicant's conditions creations and then strike fighting out.
Thank you.
Stephen,
Work. The section of misconduct in the application process, which somewhat independent, because it does happen. You know, law students are told, you know, the worst thing you can ever do is lie on your application. You know, and so actually bad conduct that's in your application. But in terms of misconduct, people have been stated things, they've gotten admitted. There's at least one Arizona case that we looked at in the task force where, you know, somebody committed to just fraud in the process, and later on that resulted in disbarment. So it's the recommendation or the ability to review misconduct in the application process is retained there. So those subsections are sort of the nub of what the committee does in terms of evaluating.
One, talks of third line says about the character and fitness of each applicant. I would say about each applicant's character and fitness. Strike out.
In paragraph G about false and fraudulent, you had a note. Is it just?
I didn't intend to strike the last clause.
As to the application, false statements in the application process. You had a staff note. Is it false, fraudulent? False, if you say that's not true. Fraudulent, I think it has to have an intent to deceive someone. That they're two different things. Did you want to discuss that, or?
I think the working group goes to keep the fraud, just to include the intent.
Okay.
Aspect that, because there's often false stuff that's not intentional. Because, either people go back to the reconstructing past, so it has to be involved in keeping the intent, particularly in the application process. It's not a gotcha.
But what about their behavior with the admission staff? I don't see that. This is common across the country, because we have that there's not that any other. It's talk about a predictor for future behavior as a lawyer. If you can't.
So the misconduct in the application process is after the fact. We've licensed them, and this is us clawing it back. So whereas misconduct during the application process with staff, the committee and Ed and Pat are both very good about this. We'll bring it up in that we're hearing all of the communications between the applicant and staff, and then it goes under, where do we cite that one?
Certainly under relevant traits, respect for law, legal institutions. Yeah. My early hearings a decade ago, we had the security guards in the lobby testify because the person had been yelling at them and shouting at them. So.
But you're correct, Dave. Instability is on the rise in the process.
Well, it might be a substantive change, but maybe when this rule goes forward, somebody should make a comment to that, because to be able to clearly warn students ahead of time that behavior is not going to be tolerated, should be taken into account. I think it's a
we haven't talked about it so far.
rather than have it sort of.
Might be describing it.
I had a question. I was chatting with Judge Metcalf, and I'm hoping I'm not missing something, but I don't think I am. So is it intentional that like misdemeanor domestic violence is not, I read it as not included because it's not part of the
What's the serious?
list of serious crimes
Shoplifting is.
and it's not a felony? To me, I would think that that's something, but again, I'm not, maybe, and currently maybe now it's not, but it does seem to me.
Asking how does the committee handle that?
Yeah, or is that, if that were to be added, I'm assuming it would be a substantive change, not restyling, if that was specifically called out.
I think it would be handled under the next section, unlawful conduct not resulting in the conviction of a crime as set forth in paragraph B2 of this rule.
Right.
But it's not listed as a serious crime. They've been convicted of a misdemeanor involving a serious crime.
I think you might have some, look, in every jurisdiction that I know, your first arrest for domestic violence goes into diversion. So that if you actually get a conviction for domestic violence, you're usually a repeat offender.
Well, I didn't even know that. I did.
So that may cut in putting this in the serious crime category explicitly. I know of no jurisdiction where you don't. And the idea, the social good is give people sometimes counseling to deal with their issues. But if they commit repeated ones, you can only get one of those.
Well, you consider all crimes. It's just that these are like a presumptive knockout.
Yeah,
And so it's not that it wouldn't be considered, but do you want it as presumptive knockout?
Well,
Where do you?
I would be a little bit hesitant about that, because you could have a circumstance in which somebody throws down a cell phone, commits criminal damage, and if it's in the context of an argument with their significant other, that could result in a domestic violence charge.
Yeah, that's absolutely true.
And that would fall under F,
But
right?
even so, that's part of the reason why these first ones tend to be.
Like I said, I don't know if categorically you would want to say every domestic violence offense results in a presumption against admission. The disclosure of it and the circumstances is what we count on in the committee to look at to determine whether or not it should. Or if there's an explanation for it, rather than result in that presumption. And if you did get a conviction, well, now you're dealing with something else.
But what if it was a misdemeanor?
It's going to be a misdemeanor.
Yeah.
But you can have multiple misdemeanor convictions for domestic violence that could involve circumstances where it really wasn't an act of violence against another person. It wasn't a person crime. It could be a property crime.
I mean, it still would be disclosed and but could the CCF do further investigation? Because
But how do they consider it though? Because I thought we had our Chief Justice tell us this is setting the guardrails, and I don't see any other under the relevant traits and characteristics. It's not a conviction of that particular crime. It's not other relevant conduct. If this is setting this is where the playground you have to play in, this is the gutter, the out of bounds, where does it say that any conviction can be considered? No, because that says not resulting in a conviction of a crime. Unless that, as set forth in D2, is saying that allows everything else.
Yeah, it's a conviction of a crime. It's just not the one set forth in D2. So I thought what she's saying is not necessarily one that's going to be in D, but it's another crime.
Yeah, as long as you can consider it, that's my thing. Like, you have to be able to consider a conviction for a crime, just because it's not a serious crime. Because there are crimes that I think are serious. I would say domestic violence crime is.
Presumption doesn't apply.
Right.
It was so section F.
Yeah.
It's still considered as an arrest. So you could still be arrested.
Even a
But where does it say they get to consider arrests in here? That's what I'm saying.
But you have to report all arrests.
You do, but this is what they are saying they have to consider. I agree you're reporting it, but this is telling you what you actually get to consider. And I don't see anywhere here where it says you can consider that you've been arrested 35 times. If Pat says you're declined because you've been arrested 35 times, I would say, show me where that is a factor that you are permitted to take into consideration.
Respect for law. Respect for law is so broad. You know, that's every crime, civil, criminal.
You thought you had it out?
I think we should make this clear. I think when you were stretching and bending to say, well, respect for the law is going to, why wouldn't we just say point blank, if you've been arrested for a crime, if you've been arrested, we get to consider arrest. If you've been convicted of a crime, we get to consider it. Why isn't it just explicitly stated as opposed to this tenuous connection?
It is under G. What used to be F is now G. And there's a whole chunk of stuff under G.
No, it doesn't say arrests. It does. One, I guess.
Keep scrolling down to G. Right there. Now, could there be something that said
but that's not included in factors.
Other relevant conduct or the factors that says specifically criminal conduct?
G, yes, like
Results in.
then B should be considered for one of those factors that they're considering, because it just stops at other relevant conduct. It doesn't say evaluation criminal history, or it doesn't say how F actually applies. It says you get to consider it, but doesn't show where it actually would apply. So that, I mean, that's the way that
It's almost like a phase 2. And those who are on the committee know this works better than I do, but you're going to evaluate everything that you're typically required to do. Then you would get to this, which is sort of like the potpourri. Haven't considered it previously. You get to here, you're going to evaluate it.
Is there a way through this to stitch D and what's now G together? Put something at the end of D saying convictions of other crimes shall be considered under G. Because you're right, there is kind of this odd, Jessica, to your point, this odd sort of hole in the donut.
Yeah.
In D that's not just for domestic violence offense, but for other offenses, other convictions as well.
Yeah, like shoplifting was a good example.
I think the C, relevant traits and characteristics, honesty, trustworthiness, diligence, reliability, respect for law, legal institution, or ethical codes. That is incredibly broad. It is a fishing expedition of unbelievable breadth. And what the later sections do is narrow that for certain purposes. So the next one, conviction of a crime, this is a presumption. You're presumed not to qualify if you're convicted of a felony or a serious crime, which is a defined term just for this section. And so that's a presumption, and what we have to do if somebody is to satisfy the presumption, which is send findings to the court. And then the other one about other relevant conduct, the committee must investigate.
I completely agree with what you're saying. But when I read D, I think, okay, this is how all criminal convictions are addressed. And the answer is no. It's not how all criminal convictions are addressed. It's how felonies and then serious misdemeanors are. And that's why I wonder just if adding a tiny thing at the end to say other criminal convictions shall be addressed elsewhere, because then it makes D comprehensive.
I'm with you because I feel like D is telling us, oh, it's only going to be these, even though the other unlawful conduct is below. I'm with you, Judge. That's how I'm.
This sort of completes the circle. And to your point, Joel, you're right. I think old E1, unlawful conduct, actually it doesn't, not resulting in a conviction, because what we're talking about is convictions here.
Yeah,
But that is not resulting in a conviction in D2, which is those special cases of crimes. I mean, it could be more clear.
Right. No, and my point is only if you put
Convicted.
a D3, all other criminal convictions are addressed in what used to be E. Does that make sense, Pat? Does it?
Would it be simpler just to retitle it presumption against admission for conviction of a crime or other conduct? That it's specific as to the presumption.
That may work if there's an inclusion in E about other criminal convictions as opposed to other unlawful conduct not resulting.
Yeah, you'd have.
There is a fix for sure. It just seems like there's a gap, right?
Another example would be like reckless driving. Let's say someone had a lot of reckless driving convictions that are misdemeanors. They're criminal, but they're not this list.
Yeah. Could it be like unlawful conduct? That's the not resulting in a conviction.
Right. I think Sam's point is a good one to put a thing in there saying you can still consider other crimes.
The easiest solution.
There's other unlawful conduct?
Yeah.
You're getting that conviction.
It would just be like one, unlawful conduct. Unlawful conduct not resulting in conviction.
With any of those solutions, I just think there needs to be a little bit added. Completes the third one, as Judge Stewart said.
Yeah, so see, unlawful conduct, including unlawful conduct, but not convictions, not result in convictions. That would be,
yeah, I like that. To carve out what was D1, Doug, is that what you're suggesting? Yeah.
Well, unlawful conduct not resulted, it's not unlawful conduct. I think it'd be better if you separate it, make it a 1 and a 2.
Okay.
Because you've got unlawful conduct. That's a conviction.
Right. And then the second would be conduct not resulting in a conviction.
And that's to cover the serious.
Oh, no, it's got nothing to do with serious.
Let's say you wrote.
That section is saying if this committee learns of any of the following conduct, it must investigate. So unlawful conduct, is that traffic, parking tickets? Is it, it's unlawful is pretty broad.
It is.
I had to write every speeding ticket I ever got when I applied way back in the day.
But they exclude a lot now.
It took me forever.
But we should go back to Sam's point of that sentence. Paragraph.
Something in D, and Pat, to your point, it may refer you to F instead of what used to be E, because you're right, E is sort of an investigation obligation and F is a consideration.
Yeah, I think the unlawful conduct is too broad there because of the must investigate.
Yep.
Yeah.
If you want to put in something about other criminal conduct, put it back in conviction of a crime.
In D, what would become then D3, other criminal convictions are evaluated under F.
Yeah.
That's poorly worded, but
I understood.
there's hope.
I mean, that's the important part, is people understand.
And Veronica, just what I'm trying to do is in what used to be D, conviction of crime and other conduct, a new subpart in there, it would be 3. So after the to say something like other criminal convictions shall be considered under F, something like that. Again, that's awkward, of course.
David's had his hand up for a while.
David?
Yeah, I put my hand up back when we were talking about misconduct in the application process, so I don't want to interrupt this discussion, other than to say I like this solution that Judge Thumma came up with.
Veronica, I think it actually is G. It's now G. It's old
Sorry
F,
about
current
that.
G.
And I wonder if that should be shall instead of will, but I defer to Pat and the crew. Or must, sorry, but as opposed to the suggestive will, but Pat, what's your reaction? Must, is that?
Or is it may? If it's a, if it's a misdemeanor jaywalking, it has to be considered.
Well, don't you consider it and then you say, okay, it's no big deal.
I guess.
Yeah. I'll be looked at.
I think must would probably be better, but it's for that reason, but I'll shut up now.
Should we also reference C? Must be considered under, because the relevant needs and characteristics regarding respect for law.
That's how it actually relates back, as it relates back to C5.
You're right, Kate.
I just didn't know if we should have an additional internal cross-reference.
Where I get there, though, is B talks about factors, character and fitness being the big umbrella, and then it lists the three kind of things that fall underneath that. And I wonder if that might do the work.
All this stuff relates back to C, and we don't refer back to C in any of these other provisions.
Okay.
So I would leave it at G.
What about F1 and 2? What are now 2? It's not conduct not resulting in conviction of a crime. It's unlawful conduct resulting in a conviction, and that's effectively means an arrest, most likely. So I think we want to retain the.
I think we want to put that back the way it was.
Yeah. Take out the one.
Well, do you want to change unlawful to arrest?
No, because many people are not arrested.
So you have somebody making an allegation that there was unlawful conduct.
It's intentionally very broad. That's one we had one informal once where the person had shoplifting.
Joel, I think you're
Triple ask at the end, did you ever shoplift after that? Oh yeah.
They were honest.
So this is the must investigate section. So the number one, if it's unlawful conduct not resulting of a conviction of a crime, it's set forth in the 2A. So you would only then be required to investigate if they were arrested and charged with a misdemeanor that was a serious crime and not convicted. As an example. Or not convicted of a felony. By referring to, and maybe just Judge Thumma's change above captures that you could still consider. Because one is just saying did not result in a conviction.
See, I read that as not involve a conviction of a crime and it refers back. So the special group of crimes, not all crimes. So I actually read that as I could consider other unlawful conduct of other crimes under that provision. Because it refers back to just those misdemeanors involving serious crimes or felonies. That's how I read that.
So Joel, you read it that you.
Not it could be a conviction of a crime. It just can't be. It just excerpts out those convictions of crimes that are in D2.
Instead of referring back to
Back to the
D2, I think
presumption.
if you just used felony or serious misdemeanor, it might address, I think that would help if we actually use the words and didn't refer.
And Jessica and Joel, those are really good points. And I was focused on F, the evaluation, as opposed to E, the requirement to investigate. Because it does, as Joel points out, D2 does talk about what has to be further investigated. CCF must investigate further the things in E. But then in F, we don't sort of get the universe of stuff that can be considered. So your point's a really good one, and suggests that either the language I'd propose for new E should be pulled, or it should be expanded to include F and G. So my bad on that.
No, I don't think, I think you were getting, I think Joel and I was reading it as it was restricting it. But now hearing what Joel's saying is maybe I'm reading it too narrow to A through D.
But isn't that a sign of a bad rule? If you interpret it one way and he interprets it a different way, that tells me that it's poorly worded and we should reword it.
Obviously.
I just haven't had enough.
Exactly.
It's in the sign of a bad rule, two bad readers.
One bad reader.
That's the bad reader canon.
I'll go with the OnlyFans exception provision.
Trying to come up with one.
Henceforth known as the bookmark exception.
No. Ben's eyes got this big when I used that example too. I was like, oh, great.
There's no more discussion on this part of the rule. David, did you want to raise the issue that you were intending to raise previously?
Thank you, Justice. Yes, so it was G. So is it H, misconduct in the application process?
Yeah.
And I understand this is moved from some other rule. But I don't know why we have the phrase fraud or a material misrepresentation or material omission. Those are and any fraud will necessarily include a material misrepresentation or material omission. So why do we need fraud?
Yeah.
I mean, fraud has a lot of things. It has intent, it has reliance, and I think what this is intending to say is, even if it's an innocent omission, if that omission was material, the CCF should investigate. Maybe they'll find out it was, just a silly mistake. But nonetheless, worth investigating.
I think he just wants to strike.
Yeah, I guess it's a long-winded to say, a way of saying, let's strike fraud. So the other question I had by includes, are these just examples, or must the misconduct involve the material misrepresentation or material omission?
Misconduct in this sense, could that be mistreating staff?
As worded, it makes it mandatory. So the misconduct could have been forging a signature. Well, I guess that's a misrepresentation. But again, I don't know what the current rule says and what the purpose is, but we should be clear whether this is an exclusive list or just an example.
I suspect it was just an example with the idea that it's hard to anticipate what the misconduct might have been. I mean, and I can see, more often than not, it's going to be material misrepresentation or material omission, but could it be, as you say, forging, witness intimidation? I can't even think of possibilities.
Right.
Why don't you put a comma after process and say including misconduct, and go on with it. So then it'd be clear it's not just excluding.
It's not trying to define misconduct.
Yeah, it doesn't define it.
Yeah.
And
That's
then
my
that would bring in their behavior with the staff and other things.
Yeah.
I think that's better.
Again, this is after the fact, after they've been admitted. And so it's looking at somebody who is being looked at after they've been admitted and we've discovered the misconduct. So,
Well,
no, that works.
but if we make this change though, could that be where, say, staff comes to the committee and says, hey, we're working with this particular applicant, but this has been their behavior throughout this process.
Where did it say it's
Consider it contemporaneous with their application.
That's just the way it's been interpreted, I think, in the application process. Because the other factors, the dishonesty, respect for the law, the legal institutions would all come into play under the general rule anyway, if it's during the process.
So the misconduct of staff would come in, if it's known, would come in at that point.
It would be respect for legal institutions. Okay. We always tell the law students is assume that every communication is like an email to the Chief Justice of the Supreme Court, and that because it will likely be passed on to them. So.
Yeah, I would never have guessed this dealt with. So you mean somebody's admitted to the bar? Who brings an action before the conduct commission that they misrepresented?
I can't remember the case circumstances, but we talked about it in one of the task force. There was a reported decision where after the fact, somebody was accused of lying in the process and they ended up having their admission revoked. So.
Wouldn't you want to label that then more clearly?
How misconduct in the application process. I mean, that could be relabeled to clarify it's after the fact. So I'm not sure how to do that.
I get date revocation due to misconduct.
Well, it's revoked or changed, so.
I don't know. It seems like it's right in the middle of the process of applying. I don't see how this is after the fact.
Or would it be consideration of misconduct in the application process? Or investigation of misconduct?
It just doesn't fit because the next thing is you're making recommendations, so you're still in the process. It just is out of it. I read it as misconduct in the application process or an application process. And if you want to have something else, wouldn't it be after they've been admitted?
Which would be normal discipline, including disbarment, right?
Yeah. It seems like this is.
No, let's not conflate this. We're not at discipline.
What if you learned about criminal conviction afterwards? I guess that would be a misstatement, right? Because you didn't disclose it.
Omission, material omission.
If we keep it here, it seems like, because I read it like you did, Dave, that this is while you're applying, they notice it. Couldn't you just have a line at the end that would also include this? Would include after admission as well, or something like that, because it makes sense that you're considering it in this process. Like, its location makes sense if you're thinking about it right now. Like, did they make a material omission? Did they make a material misstatement as they're applying? Where it's at, that's the way it should read. If we also want to apply afterwards, it seems like there should be another line in there.
Well, it seems if you're going to do that, you have to have a process because they're admitted. Character fitness has lost jurisdiction.
That's what the rule is intended to do, is to give it back.
Then I think you have, like Ken says, I think you need a whole other section that says that. And you
I think it says that later on, right? That's the third sentence on proof by clear and convincing evidence that there was misconduct. CCF may recommend that the admission, so it's already happened, based on such misconduct, be revoked.
Mhm.
It follows a number of sections which provide the basis on which to deny admission, and this is the ultimate violation, which is misrepresenting or all of these, conduct characteristics that contain all these factors, and it just says you can pull it back.
Where in the current rule is that? I remember it sort of stood out by itself.
It's 33B3(1). And this historically, Merritt and I would Shambo for this because we both had jurisdiction, and I would say not it, and she goes, "No, I have the last one. It's your turn." So this rule was changed a while ago to clarify a little bit, but it is still 35B1, but it's revoking and suspending a license after the fact. 33B1.
Because it's based on conduct before the person became
Correct.
a lawyer.
Yeah.
Right. So you have to have a such provision for that.
Hypothetically, maybe somebody was committing mortgage fraud, forgot to disclose that in their character defense application, and we found out about it after they were licensed. And we were like, oh, that's something the committee definitely would have taken into consideration.
Right.
And so we took that one on because we knew the evidence a little better than the state bar would at that time.
If the state bar handled things that happened before you became a lawyer, because this would, you know what I mean? Because the application process could be people who are not lawyers yet. I mean, I'm just saying that makes sense why you would have.
It used to be written that we both.
Oh, really?
Yeah, that we've taken them off.
Well, and you could see a situation where the mortgage fraud is being committed, for example, while they're applying, and then it continues to be
oh, I see what you're saying. So it could
post admission too. So I can envision.
So if it's dual jurisdiction, you have to cut
potentially
it off.
both.
Yeah. Okay.
Right, we're about 15 minutes past delivery of lunch. I didn't want to break this up, but if we could wrap up, this will be a good time to break and resume at 1 o'clock.
Works.
Is it enough? Okay, I got it.
33 is.
All right, welcome back, everyone. And by way of reminder, we'll have Pat wrap up the discussion on the rule that we're currently working on. And then we're going to shift gears and go to group 4 and hear from group 4 on their rules. So Pat.
Never let it be said I can't take a hint. So you wrap up.
Well, I say that only because I think we were near the end of it. So it'll take as much time as we need to get it right.
But I think the changing the title investigation of misconduct, is that work for people to tell you that it's after admission? So we could do that. So then the H is recommendation for admission based on preliminary review. This rule talks about sort of the initial the factors to be considered, but is also how to deal with an application fairly expeditiously. The admissions manager, that's your title, right? Thanks, Marianne.
Yeah.
And so again, most of the applications are dealt with by staff, because they're clean, they have no issues. And so when I joined the committee 13 years ago or whatever, a committee member had to sign off on every application. And so that for most people that was unnecessary. And so it allows the admissions manager designee to review all applications and look at the categories. And as I say, the provision earlier in this rule for then further investigation are triggered if the admissions manager sees things like that. Then the direct recommendation, the manager informs the committee and then certifies to the court the name of applicants who could be considered without further investigation. So the idea is to be very expeditious. I know the staff tells people, if you're graduating law school, if you get your application in before you graduate, and certainly before the bar, then be admitted as soon as the bar, assuming there's not. So this provides for that. So that finishes that rule.
Did we change the subsections? Do we have to offer those, the D3 or that?
I think we'll update them as we go to conform. So certainly, thank you.
I think Pat, in what I suspect is the unlikely event that we'll get through all of the other work groups. If we have time left over, then we will return to you to start with the next rule. So just to put you on notice.
If we have time, we'll move on to further investigation.
Yeah, so I can test. So Merritt and Kent.
I'm gonna take Rule 49. You will note that most of these are just really the changes based on the style guide. There are two places that I'll point out. We have made the substantive change to the, I guess it's substantive length. Major change to things, but just to go through these, Rule 49 talks about the responsibilities of Chief Bar Counsel as well as responsibilities of Bar Counsel. And so if you'll note that it's broken down to a few different areas, but most of this rule really, when it comes to the Chief Bar Counsel, is to direct where and when others need to be notified. Right. So in subsection A, this is appointment of Chief Bar Counsel, which has to be approved by the court, and no change other than to utilize the principles of the style guide. Next, B, oath of office is an oath that has to be taken by Bar Counsel and filed with our manager. Powers and duties in C of Chief Bar Counsel. There is oversight. This is one area to just pay some attention to. So with the oversight of Chief Bar Counsel, it's to maintain an office for the purpose of regulating the practice of law. It specifically talks about investigations of lawyers' conduct and supervising the staff needed to perform the investigations. And you'll note that there was a staff note at the top. So we were going to return to this later regarding the UPL, because nowhere does this talk about overseeing the process of prosecuting the unauthorized practice of law. And I suspect that the reason for that is that this rule pre-existed the set of rules that allow for the state bar to pursue the unauthorized practice of law. Justice Montgomery, do you want to talk about the UPL stuff now, or do you want to?
No, what I prefer to do is for us to wait until we've had a chance to go through those rules, and to the extent that it requires us to bring to the task force's attention any potential changes at that point in time. I'd rather do it then, because then we can have a fuller conversation. And then the task force can make any decisions then fully informed of what we learned from the other review. Unless any member of the task force wants us to do otherwise.
This just your way of keeping me from straying?
No, I
areas.
was going to introduce this rule though by noting that at no point in time did Merritt ever attempt to expand the authority of Bar Counsel in our consideration of something other hand. Please continue.
All right, so after oversight, we look at in C2, dissemination of discipline and disability information. So there's 4 categories here. There's notice to disciplinary agencies. So anytime we're aware of the fact that a lawyer is licensed, when they get sanctioned here, we provide to the other jurisdiction the notice of discipline for purposes of them taking reciprocal discipline. Then there's in subsection B, disclosure to the National Discipline Data Bank. Simply that the ABA maintains this particular database. We are required by rule to report to them, which we do. Then C, notice of discipline imposed. There are certain categories of sanctions that we are required to publish in the attorney. We'll see that note that we have about this, that the rule also requires that when you send notices and sanctions to a newspaper of general circulation in the county in which the lawyer maintains primary office. And I'm sure that you recognize now that in this day and age that isn't really a practicality, right? So there aren't many newspapers of general circulation for which one could send these notices. So the task force, the note is that we're going to probably recommend that we do some other notification process, not a newspaper.
To round that out a bit, there's a concern that based upon this rule, if an attorney is practicing in an area where there is no longer a newspaper of general circulation, has the state bar then failed to somehow comply with the rules, and there's a due process concern about notice, even if that's not the main way in which an attorney would have, or others would have received notice about it?
Well, isn't it the Arizona Republic? It's statewide. It's in every county.
Is it?
Sure.
Well, I think there's the other side of that coin, which is, I think there used to be the Goodyear Gazette or Daily newspaper where it's a publication of general circulation in the county for notices, which I don't know about you, but that's not the first paper I grabbed. I mean, these notices get put in those things.
Yeah. Isn't there, I mean, there's gotta be a publication in every county, because a lot of things that are published for service process.
Right. But I guess what I'm saying, even if there is a publication of general circulation in the county, nobody reads those. So it doesn't really provide real notice like it did in the 1800s when you grabbed your newspaper. So
I think that's really the point, though. This rule serves to notify the general public, right, that a lawyer has been sanctioned. And what's our discussion really centered more around what's the best way to get that out to the consumer, right? So it would be to utilize the state bar's website in a different way, because I mean, let's face it, there's information about lawyers being sanctioned on the state bar's website, but it's how prominent is it? You know, a few years back, somebody had made that decision where we were going to, use the landing page and the scrolling banner at the top to talk about recent sanctions. And that, as you can imagine, didn't go over so well. But again, I think there are things that other areas that we could probably focus on in order to satisfy what this is intended to do, which is to alert consumers to lawyers that have been really suspended, disbarred.
Still using Telegram.
So at any rate, that's what we're going to recommend, is that we eliminate the requirement to send a notice to a newspaper of general circulation, and instead just require the state bar to post it on the website so that folks would be able to get the information that way.
Would there be any place to put it on the state Supreme Court?
We could, but if you think about it, people don't wake up every day looking at the list of lawyers, which they may someday use. What people do is they're going to go look up if they're considering a lawyer, they're going to look up that lawyer's record. Just like you want a new doctor, you're going to check the doctor's record. You want to do it at the time you need a lawyer, not have to go back to a publication 3 years ago to find out if they were disbarred or not, or disciplined. So it just seems like, to me, it would be the individual records of the lawyers. Mm-hmm. We could put it along amongst the other billion pages we have on our website.
So I was not in favor of that, Justice, because there is a lot of public confusion as to who the PDJ works for and what the PDJ has access to. So if we put it on the Supreme Court's website, it's going to suggest we have access to everything that the state bar does as far as discipline, and we do not. And it's going to suggest that we work for the state bar, which is at least to some segment of the public, a very confusing thing. They constantly contact our office to try to initiate a complaint, and then they think the disciplinary clerk is lying to them, and they say, you can't do that with us. You have to contact the state bar. So that's one reason. I get why you would think maybe it's a good idea, but I think then they're gonna look at what we list for our discipline and it's not gonna match up.
Don't people now go to the state bar website, get information about lawyers?
Yeah, that's what I'm saying. Yeah, yeah.
That's what our recommendation is. Yeah.
The issue is there has to be some clearinghouse that would be equivalent to what the newspaper general circulation used to be. Where people can go when they need the lawyer. I can easily find out that the lawyers have a disciplinary problem. So where that's gonna be, I get this with the bar. But it is now. You can, years ago, the board changed it so lawyer discipline is listed under each lawyer. So if you know, if you're considering a lawyer, you could type in their name and it'll come up. There is a little caveat that says, not quite all disciplines here, but most of it. I mean, I don't know why we don't just do it all, but anyway, that's where you find it. You look, you type in the name and you find the disciplinary record. Well, yeah, there's certain things. I mean, every time you have a client file a charge, that shouldn't be listed. Well, it's not. I know it's not, but in terms of what gets listed, it's done. But I think the key issue is just how easy it is for the public to get the information they need.
Yeah, well, that's pretty easy. But the one thing that's not listed is public discipline. For some reason, the board's never said list for the court. What is that?
Definition.
Definition. Everything else is listed.
And as you see, when we go on, you'll see specifically what you're supposed to wear and how long. Yeah, right, for sure. All right.
I
So
don't
there are
know,
no.
is it, the pleasure of the task force then to go ahead and eliminate the newspaper general circulation requirement?
I think
where it has to be posted on the state bar website or?
Yeah, again, unless we go back to telegraph.
What's the disadvantage of having it with legal notices?
Cost. It's just a waste of time.
But has the rule just required sending it to a newspaper? There was no requirement to actually pay for it to be published?
It's just send. It says assure notices or sent to a.
I mean, I think even most legal notices, it's not that the public is looking at them. It's like debt collectors and, finance companies. They're the ones who look at it and they know where to find it no matter what.
But the original intent was so the public would know what's going on in us.
And again, I suspect at the time that this rule was created, there wasn't online searches for lawyers on the website.
But it's a trend. I know that if you form a corporation and are in Pima or Maricopa County, you don't have to publish anymore. You just publish it on the ACC website. So, I mean, that's certainly the way things have gone.
So back in the 1920s, nobody had that, so where else did you read?
So, propose eliminating it is.
Yeah, I would propose it's not necessary. It doesn't do anything.
Okay. So
any objection?
Who are we going to keep in the Arizona attorney?
Yes.
Yes. Arizona attorney and then the website.
Well, you got to keep the Arizona attorney. It's the first thing we all look for.
So what we do then is within C, it would read, Chief Bar Counsel must ensure notices are published in the Arizona attorney, period. Notices of sanctions or orders must be posted on the State Bar's website as follows.
And that would be different than the lawyer lookup, right? Because there's that. If you type in a lawyer, it would have the discipline, but there should be a place that just lists sanctioned lawyers that it's easy to find on the website.
Well, no, there isn't a place.
That's the question. It should be the requirement.
Yeah, it doesn't exist now. I just to be clear.
Right.
You gotta look for a lawyer.
Yeah.
Yeah, well, what would be the purpose of that, Judge? I mean.
Well, just a tab. So like.
Yeah, but why?
Because it's easier to find.
Because the search now.
They have over 10 years, you can have thousands, hundreds, and like. People are usually looking for an individual lawyer to determine whether I want to hire them or not, right?
But if you just type into Google a lawyer's name, would it right now go to the State Bar website to their history? I doubt that it would.
The other problem I have is people misspell names all the time. I have judges that have called me Volkman and a million other names. Not disrespectful, but if they're looking for me and they type that wrong name in, it doesn't say, sounds like, here are a bunch of other solutions. They have to type that person's name exactly. Where if there's discipline, they could go ahead and look and be like, oh, I thought it was Volkman. It's actually Volkmer. Here he is. I actually support Judge Metcalf's. There should be, it doesn't have to be a scrolling banner, but it should be like a tab that they can go to and they could look if they wanted to access it. If we're taking it out of the newspaper, we should make it more accessible than it currently is.
And presumably, to the extent that the list is retained, it's just placed in chronological order. I mean, as they come out, so you can see what the current ones were.
So what we do right now, and clearly nobody knows that we actually do it because it's tucked in the lawyer reg drop down, and with annual reports on an annual basis, we list every lawyer and the sanction received. So they're grouped by the type of sanction. So you could look at them that way. But again, it's not really something that's visible or terribly visible, but of course we can change that accordingly, but you could do it by year, you know, and then just sort by sanction.
Well, then how the state bar does it would be the next step, at least initially having the rule reflect the fact that you don't have to provide the notice to a newspaper general circulation anymore for public notice. That we go right to that last sentence of C. Notice of sanctions force must be posted. And it needs to be then posted in a way that we can replicate what the notice was otherwise supposed to provide. Exactly. So that's how we would then change that.
If you're gonna do it, you need to be able to make it sort not just by year, because the public's not gonna know what year it was this lawyer, this part, alphabetically, sort, you know, by year or alphabetically, because you won't be able to find it otherwise.
I would suggest by county as well. I mean, that the newspaper was supposed to sort it by county. Maricopa County doesn't do nearly as good, but if you're in a smaller county, if I could look at Pinal, if I could look at La Paz, if I could look at Santa Cruz, that's the pool of attorneys I'm looking at hiring from. So I think a search by county is consistent with what that says.
But is there a way to meaningfully know that? Because there's attorneys that practice all over the state.
Be wherever their office is. I mean, that's what the rule requires right now. It's wherever their primary office is. That was the newspaper you had to publish before, is wherever their office is housed.
Wherever your office of record.
Where the lawyer maintained an office for
address of record.
There, to be clear, if you were doing the lawyer search and you put a lawyer's name, the information would still be included in the individual's profile.
For sure.
Right, yeah, so you don't have to scroll to see if the lawyer you want to hire, it still would attach to that profile. This is just a separate post.
Then moving on, we have the specific types of sanctions that have to be posted on the state board's website. So
I'm sorry, real quick, before we move on, I just had a quick question, and it's a logistical question about the search on the state bar's website. I've just noticed that there are lawyers who, so I've done that before. I've searched for lawyers, used Find an Attorney. I've noticed that sometimes I know there's discipline and it doesn't show up, and I get this window that says discipline isn't always posted. And I'm just curious as to what the decision calculus is for determining whether those will or will not be posted, because it'll either say none or it'll say discipline, and here it is, and it'll give that little summary. But then you get that weird gray area, and I was just curious as to why that exists, and if it's
there's only one sanction that isn't posted, and that's an admonition. Everything else is posted. I shouldn't say everything else, because there are some dispositions that are not public. But essentially, if you get the little not pop up, but their little response that says not all lawyer discipline is posted on the website. If you want a full history, click here. The only thing that refers to is an admonition. And that was a decision made in 2009 when the court was looking at the overall rule, comprehensive rule changes.
People should really look at that and just make it all or nothing.
Of course, because we don't have anything, we don't have any non-public discipline.
Right.
So it doesn't make any sense that there's this one outlier that you have to know about. Do the right wink, nod thing, and then you get the information, because it is public. It's just not posted.
Right. Well, and my thought is either we need to account for that here in what we're describing or something else, because right now, again, like there's nothing that accounts in these rules for that gray area either.
Well, where is that, Meredith? Was that the court rule that said you don't publish those, or the bar board?
No, it's in Rule 49.
Oh, okay. I must have missed it.
Well, in order to cover that, then what I would suggest we do is we just say, Chief Bar Counsel must ensure notices that are previously discussed comprehensively are published in the Arizona Attorney and posted on the State Bar website. And then when we go down to the last sentence, specific notices of sanctions or orders must be posted as follows, and then provides a prescription for those two things. So Veronica, yeah, there we go. Thank you. There, and that'll make sure then Judge Common, which you mentioned, doesn't get overlooked.
I still think an admonition would still be posted.
It wouldn't be, because it gives the list down there below.
Yeah, that's right.
Well, that would be for sanctions and orders, but if for public notice of discipline imposed, Chief Bar Counsel must publish notices of orders or judgments of reprimand. Wouldn't that encompass an admonition, or no? That's
you'd have to say admonition.
So should we add admonition then?
When the court decided that it was a political compromise, because in those days, nothing was being put on the web. There was a big debate amongst the lawyers in the bar of putting lawyer discipline on the web. And so they were like a compromise. We're going to put this on, but not these.
You can put an admonition on as long as it has probation with it.
Yeah. And so it would be a nice time to clean it up, but it is a substantive change.
Okay, well.
And it would eliminate that confusion where people see that, hey, you got to call us to get the total record. It's kind of silly.
I'm going to speak up for this. So, with all due respect to everybody, I mean, if you talk to the lawyers, the bar's job is to protect the public. Understand that. But to have somebody who's done something maybe 20 years ago and still have this on the website, I mean, people are in private practice, people have children, people are trying to make a life for themselves. So just to keep embarrassing them. I mean, with AI, Google, you can find out a lot of stuff about people. So that was even my opinion, not to just keep embarrassing people. It's on their profile, it's right there. You don't have to have a whole list of other people.
There's only certain things when we get down to C1 that have to be posted permanently. So an admonition wouldn't have to be posted permanently.
Well, it's not posted at all right now. It's only posted if it's accompanied by probation in number 2. So I think that's the issue, is that to the judge's question. It was like, not everything's there, and as Mayor points out, an admonition, straight admonition, isn't going to be there. And the arguments at least at the Board of Governors, as Benjamin kind of talks about, is that balance between how much should be there. You balance that protection of the public, but how does it impact that attorney? And when you have conduct that isn't as serious and results in a lesser form, does that need to be permanently there or not? And that's been kind of the debate.
That's a good point. The newspaper is a one-time publish, and that's it. It's gone. You're a 35-year practicing attorney. Something you did as a 25-year-old is still showing up there. That does seem.
So you can find those old editions of newspapers now. They're continuing to be curated online. So at the event point, you can still find it if you want to look at it, if you knew how to go. Okay, well.
So, but just also recognize that what is there indefinitely, or what we change to call permanently, are the most serious sanctions, and those that have to be imposed by either the presiding disciplinary judge or the court. And then as you start to look down, like things like probation, contempt, restitution, those kinds of sanctions can be imposed by the committee, and in sort of recognition of the fact that they are less serious than the reprimand, suspension, or disbarment. They're only posted for 2 years or until completion. So there is some recognition here that not everything needs to stay there indefinitely.
To your point, and they don't stay forever.
Well, disbarment, suspension, interim suspension. I don't have a problem with those. Reprimand seems a little tough. Seems like reprimand, at least in my estimation, reprimand should be bumped down to probation and have a time frame and go away. Disbarment, suspension, I get those permanent, but that first C1, all of those never go away. Even after you've died, they are still up there indefinitely. Seems a bit excessive, but
Yeah, particularly when somebody successfully completes probation. So I agree with Kent. Yeah, publishing an admonition and a reprimand, in my view, is the modern day equivalent of putting someone in stocks in a town square.
So reprimand too?
Well, we haven't added admonition.
Certainly
But if we're going to reduce anything further than that, I think that's a substantive change. There should be a rule petition allowed for comment beyond.
I agree. Flag it, flag the issue.
From the public point of view, it's pretty hard. You don't get them, and I appreciate what Ben's saying, but it's not that easy to get public discipline in the bar system. It's a very small fraction. I always look at my doctor. Would I want to know if my doctor was disciplined before I had brain surgery? Yeah. And I want to know that. Well, attorney has real important duties they do with consequences for you. I think the public should know that. Now, reasonable time period, fine. But
So we've recommended how we're gonna communicate and post what we're currently required to. I think if we want to adjust what we're required, probably that begs for a broader conversation. So we're C1.
Yep. So C1 are the things we were just talking about, the most serious sanctions, disbarment, suspension, interim suspension, or reprimand and reinstatement are on the website indefinitely. Under section 2, you have probation, which is posted for 2 years or until completion.
Yeah, these are all just restyling changes.
No substantive changes to any of this. So 3 is the contempt finding on for 5 years or until purge. And 4, we have the disability and active status posted while the order is in effect. Administrative and summary suspensions, while still in effect. Modifications, reprimand, and licensing after a period of residence is involved in this. That indicates permanent. So
Was the thing that you wanted flagged that man might want to be revisited, or the addition of admonition?
Well, I think both. Look for arguing for both issues.
Yeah.
So then in subsection D, we have noticed the courts of any orders or judgments of suspension, disbarment, reinstatement, or transfers to and from disability and active status. You'll note that there was, there's a staff note that we're going to suggest striking the sentence. In addition, Chief Bar Counsel may petition the proper court to take action as required to protect the interest of the public, the member, and the clients, and the member clients. And we honestly had no idea what that meant. And I said, in my role, I can't think of one time where I would have relied on this to do anything. I don't honestly understand what this is suggesting we have the power to do, but in light of that, we did not see that it would really create any particular harm to suggest removing that sentence.
So we would be conforming with current practice. Any member of the task force thought that there was some reason or had some sort of institutional history about why it was there and a need to keep it, in which case we have a formatting suggestion, but otherwise we would just get rid of it.
Is it possible that this is intended to let judges in pending cases know that the lawyer in those cases is no longer licensed to practice?
Well, yeah, I mean, that's what the notice is for, right? But
Yeah.
that particular sentence suggests that the Chief Bar Counsel may petition a court to take some other action.
Because the court got the notice and sat on it, didn't realize what it was. I mean, something more affirmative than just providing a notice. I'm just guessing that was the purpose. You can be a little more active and not just be passive about it.
Well, and sending a notice to a court doesn't get it to the judge. So you send a notice to the clerk of the Superior Court, Maricopa, it's not going to the 200 judges and commissioners there. This just doesn't make any sense.
Although we do get a circulation every month, a list of people who've had bar issues. We send it out to everybody.
But this is for taking further action.
Right, no, we just get the list of
Yeah, you
names.
get the name.
Yeah, I think that would happen from the first sentence to the providing notice to courts. But, there's the question and, and this is an open question to everybody here. What additional action would the Chief Bar Council petition a court for? Would you, as a non-party to the action, petition the court to determine counsel?
If I may. So I am this working group, and I was the one that took an opposite position on this, and unfortunately I was hoping to get the floor before Judge Kelman stepped out, because I was hoping she might indicate what her opinion is. The term petition, I think, is intentional. I think petition could be referring to probate actions. So, for example, if it's a disability, or if there's issues in a disbarment where you think that the individual lawyer may need someone to either be a conservator or a guardian, or if they have mental health issues that need to be considered, anyone can file a petition in that regard. And I think that it's appropriate that we are giving that ability to bar counsel. They would have intimate knowledge better than maybe others to seek out that type of assistance.
Didn't we, when we in the task force, didn't we talk about that it might make sense for you to order them to do it when you have a specific case? Or to your point, then maybe it should be petition the probate court, because nobody in our task force other than you knew what this meant. And bar counsel's never done it. So it's like
Judge Coleman's back.
if you're going to have a rule, it should be clear enough to say, here's the action they should be taking. Otherwise, what happens?
Judge Coleman, with respect to that sentence that's highlighted, is there anything that bar counsel might do to petition you to take action that would?
So Amy, while you were out, I was saying that in my mind, there might be circumstances in which bar counsel should have the ability to petition guardianship, conservatorship, or if there are mental health issues, an UPC type matter.
Well, so I think that makes some sense, because, and we do have, the backdrop for if a lawyer becomes incapacitated, but there has to be a way to get that moving. And so I think you're right, Lisa, that having the ability to put that out there, or even a request for a guardian ad litem appointment, would make sense too. And then, of course, we all know that attorneys are supposed to advise us if they've been suspended. But I've had attorneys who just disappeared. And I found out it was because they were suspended as an interim. But it's always good to know. And so even petitioning the court to take action in certain circumstances and say, we've just learned that this attorney's been suspended. They haven't warned anyone, and you may want to take, and even just say, you may want to take action in these cases. Like if I had a trial set in a week, just somehow alerting me to it so that I could take sua sponte action would make a lot of sense. But I think that the ability to petition, even for the appointment of a guardian ad litem, instead of being the petitioner for a guardianship, would be a good way to do that. I don't know if bar counsel would want the level of responsibility that would require pursuing a guardianship petition, but to ask for a GAL would make sense.
We currently have the rules that allow for conservatorship. So when a lawyer's is disabled, disbarred, deceased or disappeared, all the Ds, right? That we have the ability to ask the court to open a conservatorship, and then we manage the lawyer's practice from there. I say we because I'm referring to the state bar in general, but it's not a regulatory function, which is what this is suggesting, that this is some opportunity for the Chief Bar Council to petition the court. So again, there is that opportunity through the rules to assist further. I guess I still question whether, if there's a couple different ways. One, we're required to provide notice to the court, but also the lawyer is required, when suspended or disbarred, to notify the court, their clients, opposing counsel, that kind of thing, of the sanctions. So again, for me, it was just hard to imagine exactly what this referred to. I've just never, if you would have asked me if this sentence was in the rule, I would have said no. I don't recall really ever seeing it. It's not something that gets referred to, nor is it anything that I can ever recall it being the basis for us doing something. So.
Well, and keep in mind, this is a May. This is all optional.
And so one of the concerns, if you remove it, that suggests that we're narrowing. So it would suggest that you don't have the ability to petition if in some future situation I've only had this position for about a year and a half, but I have seen some default cases where Bar Council has come to us, the panel, and said, we have some real concerns about whether this person has barricaded themselves in a home. And I think the May is a good thing. I'm not saying the state bar should be required, but there may be circumstances in which you would want to at least assist the courts to be aware of a situation.
Actually, that just made me think of something else, Lisa, which is the possibility of a petition for a court-ordered evaluation for somebody who's going to be a danger to others.
That's what
Well, the original sentence uses the word shall.
I think we should change it to may.
In the existing rule, it says Chief Bar Council shall petition. And I think where we are is that Merritt says she's never heard this implemented or isn't aware of it being implemented anyway. So
excuse me, just 1 second, everybody.
Two things. One is, should that shall, and if we keep it, should the shall be changed to may? And then second, is it even worth keeping if it isn't enacted in any way, isn't used? So.
There's a third point as well, is that if we do keep it, because this is a duty, it actually belongs under the duties and responsibilities of Bar Council section rather than here. Sounds like, subject to objection, that want to keep it, that should be a may, in which case we should move it down to, as noted, under D and make it a new number 9.
But Justice, it does say Bar Council must there. So the beginning of D says must.
Yeah.
I agree it should be under 9. I think it makes more sense there, but I that must is, I don't know how we get around that.
Well, if you look at D2, it says use discretion. So we could say Bar Council must use discretion to determine whether.
Yeah, no, that's right.
Barrett, what is the mechanism or vehicle to promptly advise all courts of one of these orders?
The distribution list that so it goes by email.
See, I tend to fall on the side of retaining this in some form or another, because that's a rather passive act. I mean, you send out a distribution, you think nothing more of it, but conceivable world where that doesn't get to a particular judge and he or she not aware of it, and opposing counsel is not aware that the person has been suspended or disbarred, and litigation is proceeding apace, and somebody finds out and they call you and say, hey, this person's disbarred and he's he or she is representing someone in this matter. But for whatever reason, that person didn't take it to the judge, him or herself. You're aware of what's going on and the potential for harm here. And without something like this, would you be more reticent to do something in a context like that?
It's a little more informal. So even the scenario that you're suggesting, we would just contact the judge. If it's circulating back to us that the lawyer that we know is suspended or disbarred keeps showing up, or he, heard from the client that says, I'll be hearing next week, we would contact the judge directly to just say, please be advised that this lawyer is not, but doesn't have the authority to practice. So again, it's just this whole notion of like petitioning a court. It just, I'm not.
Well, perhaps we could pick a different verb there that would cover informal contact or formal action if, a situation arose.
If you're describing a different situation, yours does fit better under the notice heading.
Oh, I understand a formal petition in a specific type of
I mean,
proceeding.
she's talking about taking an action unrelated to just notifying the judge that they've been suspended.
Right, taking an action to further constrain the lawyer in an action involving just the lawyer. I understand that.
Well,
Or protect the lawyer.
Oh, sure.
Right,
Of
yeah.
course. Yeah, it doesn't matter what the purpose to constrain the lawyer is to protect the lawyer or a client or.
So Veronica, if we delete that new 9 and go back to the after a wholesome conversation. So maybe just with the restyling edits, leaving it as a may, we leave it right where it is. This action is contingent upon providing notice and then needing to do something more.
Is petition though the right word? That sounds like you're filing a document in court as opposed to notice or advise.
Or what do we just
Judge
say?
Vandenberg pointed out, it may actually contemplate filing a formal petition in certain circumstances, but given the title of this section, certainly notice seems to be a primary concern here. So whatever language we include, you could include the formal petition, but also include a different verb that would capture and authorize the Chief Bar Counsel to take informal actions directly with the court involving the lawyer.
Wouldn't you separate the two and wouldn't this be noticed like to the judge? Like, and then to Judge Vandenberg's point, wouldn't it be under the duties? And to deal with the must, you could say, in addition, they may do this. You talk about filing a petition to protect the public. That's a duty. That's not a notice.
You could, they may take action.
But, or it could read, the second sentence could read, Chief Bar Counsel may take further action as required to protect the interests of the public, the member's clients.
That would include calling and advising like they currently do. That would include the petition as well.
Very good with that.
And then subsection is just the reporting requirements. We just changed our shall to must. Then we have the duties and responsibilities. So essentially what's set out here is sort of a mirror of what is contained in Rule 55 and 55.1. Again, no changes to the substance of what the requirements are. We have reference pre-screening, discretion.
I think I just want to highlight for members of the task force that D2A, we deleted that sentence about bar counsel must exercise discretion in initiating investigations because that's already reflected in that previous rule. So we also eliminated redundancy in what we were telling Chief Bar Counsel to do with respect to the investigation and the pre-screening.
Yes, I should ask if anyone has any concerns. Again, this is just the style guide, the use of the style guide. Any issues with what is being recommended here?
Yeah, I just had some phone stuff. Starting with 49C, what you have below lecturing, it's not just sorry. All right, instead of a colon after duties. Then in subpart 1, it's a real long list. I would make it a list, so I put a colon after it, but don't list. Then have A, rise, and semicolon, B, supervise staff, and C, file statistics. Then in 2A, I thought it was a little ambiguous. It says the last sentence says the respondent must identify in writing to the chief bar counsel any other jurisdiction. See, would be something missing. Maybe it's in which he or she is admitted. Yeah. In B, this is another list, but only the preferred point that we identified the respondent. I don't know if that's necessary, but that notice of all public discipline is directly imposed against a respondent. It's up part C. I thought I don't exactly like accurate because they're not only just notice of discipline, also you're including reinstatements. Which isn't this maybe I would just say public notice of actions taken. Within that C subsection, Roman numeral 2, last line says the terms of the order, or save the order's terms. That's if it saves the subpart 3, finding contempt of the Supreme Court order must be posted for 5. It's numeric 5. The order's effective date. The terms of the order, I would say the order's terms. That's 5. And further down in little b, this is a list. And so the first letter, each of the items should be in lowercase. And in B2, it says use discretion initiating and screening investigations under Rule 55, Part 1. And hates this. We want to strike the semicolon, which is say, and she is a council member, supervise and investigation. I think that's right. Except part 6, D6, refers to the respondent.
Well, hold on, John. So at the end of each 2A, 2B should be an and?
Yes. Actually, just B, just that, not an A, but in B. And in subpart 6, refers to the respondent, the disposition of each matter. I would say each disposition. And respondent of each matter's disposition. Save sentence.
Move on to Rule 50.
C1, maybe it's this word, it used to say members conduct and talk about kind of business structures. Now it just says lawyers. That intentional change that maybe the lawyer could define or somewhere else. Yes. That sort of thing.
Legal paraprofessionals, but not ABSs. Included ABS in the definition.
They have the compliance or, okay.
But it did used to say, right? Isn't there a strike through including alternative business structures?
Sounds like there is a definition of different rules, of what a lawyer is. Client lawyer would fall into that, but not the entity.
Okay.
Sorry.
It's in C1 on this. That a member's conduct by member, including an affiliate member, non-member, including alternative. Like existing language.
Got it. Thank you.
And I was just thinking, you know, if legal paraprofessionals reading this rule, if we don't point them to a lawyer as defined in rule XYZ, whatever it is, that might be helpful for the casual reader. This is pretty in the weeds type rules if you're.
But you're right, it also takes out ABSs, the entity. And the bar not only would investigate the compliance lawyer, but the entity as well. And this now just says lawyer.
Didn't we have a definition section earlier?
Yeah, but I don't think we put ABSs in the definition of a lawyer.
Compliance lawyer.
We put the LPs in, and I think because
We did.
Did we put ABS in as a lawyer?
But it wouldn't include ABS as part of lawyer.
Right.
Yeah.
I think someplace else respondent says can't be a lawyer, legal paraprofessional, ABS.
But this now says.
Suggestion to flag this, that to say a lawyer's conduct, a lawyer as defined by rule is.
Well, it should be respondent.
Okay, well, let's just know that we need to double check the definition to ensure that we're covering lawyers, legal paraprofessionals, and ABSs.
Good catch.
I had one question from Eric. For 2A through BC, I'm assuming it's obviously I shouldn't say, it's intentionally chief bar counsel, but is it ever your designee that's preparing the notice to disciplinary agencies? It's always.
It says me, that's my responsibility, but
Okay.
I utilize staff. So
Yes. Okay. I thought there was somewhere else where it had a reference to a designee, but I saw that it is carried through to here.
Thank you for 53.
Okay.
Designate for
49A.
appeals.
That part above where we just changed it, lawyer to respondent, this is launching an investigation, right? So they're not actually a respondent yet.
Yeah, I think that's better to know there just to confirm that that's defined, maybe to point to wherever it is.
It's an earlier point, rule 46.1 definitions doesn't include lawyer. It may be.
What you say, it doesn't include lawyer?
I'm sorry?
It doesn't include lawyer?
No, not 46.1 under definitions.
How come not?
But it might be in rule 2, another set of definitions, but I don't have that yet.
That was an early on discussion, I think, counsel, lawyer, attorney, and how it interacts with legal paraprofessionals, community justice workers, anybody else who might be.
It seems to me that an LP and a lawyer should be similar. They're representing clients. An ABS is a non-lawyer. I mean, it's a law firm. It's not a lawyer. It seems like ABS would be separate.
It's just that because the ABS is required to do many of the same things as a lawyer or legal paraprofessional, it was, I think, grouped together. I mean, I hear what you're saying, and I think we'll have this opportunity to go back and look when we have to find things, so it's consistent across the rules.
We define responsiveness earlier. Yes.
Didn't do it in who either. But we'll take a look at that. Okay, so we've got that noted. Thanks, Veronica. Okay, any other questions then on Rule 49? Okay, we'll move on to Rule 50 then. So we'll report back next time on how we have adjusted that specific provision.
Well, Rule 50 is the Attorney Discipline Probable Cause Committee. I do sit on ADCC, and there have been some sections that we've stricken in its entirety, a couple minor tweaks, and then reorganization. One of the first things we did is we pulled from section E and turned it into A, and that's the powers and duties of ADPIC. And that was just to put, first and foremost, this is the authority that it has. You'll notice in subsection 1 that we struck half the language or so. And the history behind that is when ADPIC was first created, every discipline, including diversion, had to come through the office or this committee. I was able to speak with Jo Jean Mills, who's been on the committee the longest, about 8 years. And she said when she first got on, it was not unusual to have 50 cases for them to review. And the issue is it takes us about probably 10 to 15 minutes to review a case. And they said it just became so cumbersome. There was concern that there wouldn't be the ability for that committee to get its work done in a day. So they created this provision that said, hey, we can break into 3-person panels. We can then meet, and then we can make a collective recommendation to the whole. Simple cases like diversion and those type of things. Well, the state bar was given the authority to offer diversion absent going through ADPIC, which dramatically reduced the caseload. I've been on the committee for a couple of years now. I think the most we've ever had was 18 or 19. And the reality is on those, it's 2 or 3 from the same person. I would say we normally see 10 or 12. We get our work done in about 90 minutes. The other problem that they had is this was created pre-COVID, and the idea of remote appearances was, let's say, frowned upon. I think we have 1 meeting per year where we're all physically here. The rest of everybody's appearing remotely. So kind of changes have really rendered that old rule no longer valid. So our position was to strike it. Nobody saw any current value in it. It's not going to be used. I spoke with the now chair, Judge Bailey, and Judge Bailey's like, I didn't even know that existed. Like it's never got to the point where I would recommend or use it. So the proposal was just to strike that language in its entirety. Yes, no questions. Means I'm either boring you or doing well.
I'm trying to leave room for work group 3.
Do I talk about this as we go?
Sure.
I've got a question about the phrase as otherwise provided in these rules, including ACJA. But the ACJA is not in these rules, so it's not including, right? It's in addition to.
Actually, you've said it twice in the same sentence. You've got there's an introductory clause and also at the end. So there's also as otherwise provided.
So we would strike the introductory clause.
Either one will do, but I think you only need to mention it once.
We would strike the introductory clause and make it more directive.
Yeah.
And how do we take care of David's just?
And instead of including, right?
Yeah.
And under.
And under, yeah.
And I'd also suggest in some part That, to govern the internal operations of the ADPCC, you could say govern the ADP.
Veronica, a chance to fix under A. So
Yeah,
Veronica,
so Ms.
the advocate
A.
is authorized to act under Rule 55 and is otherwise provided these rules and under ACJA. Really distracting. Sorry, John.
Do we want an and, or would it be a comma after Rule 55?
Yeah. A comma after, there we go, and then delete that and. We would delete the and after the comma after Rule 55. So be Rule 55, comma, delete and. There we go. And then the last and would also.
Do you need it otherwise?
You could stick it at the end. You could insert that clause after you refer to, oh, I see it. No. If you're going to be listing ACJA separately, you go from specific to general. It'd be under Rule 55, under ACJA 72209 and 7210, and as otherwise provided.
And then we would take out that last and say to. There we go.
Oh, you got like two unders. Yeah.
So part two would be the ADPCC's operation. Same thing in 4. We already got them.
Hey, back in the part A itself, do we need the words to act? Is authorized under Rule 55, blah, 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 2. Yeah. I think that works.
I still don't know, John, why do we have the word otherwise? Shouldn't it just be as provided in these rules?
I think you're right. It's a purpose.
Is provided in agreed.
Okay, so are we down to B?
Okay. We actually made some tweaks and tried to correctly stylize this. One of the major changes that we made is you'll notice that we struck the shall appoint the members of the committee considering geographical, gender, and ethnic diversity. And one of the reasons is it says after considering diversity, we made it more generic instead of referencing those 3 specifically, because one of the things on the committee that I've noticed is there is a concerted effort to make sure that there are representatives from a diverse field of practice. So there are people that practice criminal law, there's people that practice civil, people that practice probate, and it appears that they're making concerted effort to make sure that the group that's looking at it represents all those different areas. And this said the only diversity you should be considering was, again, the geographical, gender, and ethnic, and not all types of diversity. So we believe this broadened it and is more reflective of current practices. We also struck non-lawyer public members shall have the same powers and duties as lawyer members. Part of the reason we struck that is that actually conflicts with subsection D, which says, I think only a judge or lawyer can be the chair and vice chair. So they don't actually have the same powers. They have different powers. Otherwise, I don't believe any of those changes are substantive.
Yeah, just according to the numbers, and the styling convention is anything above 2 is it's numeric. So in the second line, it should be 9 under 9 numbers, including number 6 active, and number 3 Three non-lawyer public members. I think earlier we started a convention, when we referred to the Chief Justice, we capitalized the first letters as C and J. I don't feel strongly about it, just need to be consistent with that.
Okay. We're gonna turn to office.
Yeah, I had a question I wasn't quite sure how it worked. The Chief Justice, after considering the diversity of the committee, I'm using committee for the acronym, will appoint its members. And now you're taking that out, but shouldn't it be the Chief Justice? They're needing to appoint members with a variety of different characteristics, which shouldn't be limited, I get, to geographical, gender, and ethnic. But what is, after considering the diversity, I don't feel like that gets you. Shouldn't it be something to the effect of, if you want to expand that, the Chief Justice shall appoint diverse members to the ADBCC, as opposed to they're going to just consider, because before there was a requirement that appoints members. They consider geographical, gender, and ethnic diversity. This now they're going to appoint members, but the definition of diversity is expanded.
I read it as after considering the diversity of AdPIC. So after you look at geographic, gender, ethnic, practice, you're going to appoint members consistent with that. Is the one half dozen the other?
Right.
Fire away, Ben.
I have the original wording. It generally says what it is. Diversity can be a very broad term. But this right here is telling you these are the people that we believe that should be fair and encompass who's on our committee. So I'm fine with leaving it one way. Because I don't think we need to change it.
Judge Callan?
I think it's okay to say that we're considering diversity, but not necessarily, what we don't want is any accusation that diversity is the primary goal of appointments. I think people are very sensitive about that. And I also think that we're better off stating just diversity overall. Otherwise, yes, we could say geographic and practice area diversity, but then it just kind of keeps spooling out. So if we keep diversity as kind of a minimally defined term, I think we leave more wiggle room, and I think that puts us better off.
So, Jessica, is your point that it really should be something like, in deciding who gets to be appointed, the Chief Justice shall consider diversity needs of AdPIC?
Yeah, because I read this, not that a Chief Justice would do this necessarily, so that's why I get the comparison is, I think implied is they're going to look at it, see what we've already got, and ensure further diversity. But that doesn't say that. They could say, oh, I'm going to look at the diversity. I don't really care how diverse it is, and I'm going to pick these, 6 criminal lawyers or these 5 people from whatever. So and it seems like the rule as currently written is more a mandatory of what the Chief Justice must do. Or this to me is I'm not informed, right? I just thought there was a bit of a difference.
So I think we have to have the diversity of, if we get back and have it written like this, I think the diversity of practice gets lost, and there's a major issue there. I don't want to get into the specifics, but we had a specific case where a prosecutor took a case to a grand jury and got a no true bill, and they tried to sanction the attorney, saying that that's a per se violation. And I was like, hold on. And had there not been a prosecutor there that ever, like that attorney could have potentially been sanctioned, which would have completely blown my mind. There was nothing inappropriate other than a no true bill was found. And that can't be, I mean, being wrong can't be the basis. And once it was explained, the group was wonderful. They were great. They're like, oh yeah, that makes perfect sense. But this says the diversity should only be on those three things. I think the diversity should be much greater. I think the Chief Justice is certainly bright enough to know that, but why would we restrict them with this language? That's why I think the generic diversity is better. And understand your position, Benjamin. I get why you want that there, but I think we need it to be as broad as possible so the Chief Justice gets to pick the best person to represent to make sure that everybody's interest is being protected. I mean, that's what the committee's supposed to be there for.
All practice and diversity includes not only subject matter, but type of practice.
Certainly.
Public, private,
Yes.
small firm, solo, big firm.
It's only got 9 members, guys.
Right, but you would be shocked, Dave. I'm telling you, every time one of us will say, based on my practice, and it's like, oh, I didn't know that. There's people that have done nothing but PI. Well, in the PI, this is so unreasonable, the position they took. It's much like when you get a doctor in a med mal case, you have to have a doctor saying, yeah, that is not within the standard scope of practice. That's how it's being used. Now, if that's not the way people want it to be used, then maybe we should have another discussion. But that's how AdPIC is used. The kind of subject matter expert in that area is sort of saying, yeah, that is completely inappropriate, or saying, wait a second, that's really not uncommon for that area.
I get it, but I'm just saying, given all of the list now of diversity, you can't do that with necessarily 9 members. You're going to do race, gender, geography, type of practice, public, private, with 9 members. It's pretty tough.
So it's just a consideration. But the last clause, who serve at the pleasure of the court, that's a bit inconsistent with the fixed terms. And shouldn't that actually be in the next section then? I mean, because they have terms, they expire, so the replacement, they roll over. But if they serve at the pleasure of the court, then that's sort of a qualification under C. So maybe that could be members serve at the pleasure of the court at the end of C. And we could simplify that other sentence since that clause is gone. So it could almost say the Chief Justice will appoint its members after considering the the diversity.
So Pat, I think that who serve at the pleasure of the court was put in there because a bad member can be removed. I think that was the.
Well, that, and it was an effort to try and summarize what's originally in there, that the members of the committee shall serve, it may be removed.
There's no problem with that, but it qualifies the terms part more than the appointment part.
Gotcha.
Maybe right at the end, C, members serve at the pleasure of the court.
When the serve of the pleasure be after the 3 years?
No, I think it's at any time. I think the
No. I mean, when it fit there.
Oh,
Remember, see, because it is a little inconsistent. You say they serve at the pleasure, they serve a 3-year term.
yeah, I think it qualifies all of C, which is even if the Chief Justice extends the term for good cause, they still continue to serve at the pleasure of the court.
However, keeps it an extended term for good cause. Members serve at the pleasure of the court.
And could that start with saying APDCC members serve for a 3-year term, except that a member may continue? In other words, the Chief Justice appoints it is sort of dealt with in the prior section.
Yeah.
You don't need that.
The other two, the name members of the ADPCC, say the ADPCC's members.
Or for a 3-year term.
Get rid of a couple.
Yeah.
Do you need that second ADPCC since you're already saying it in the first sentence? Yeah. Assuming you were saying strike the chief justice. of
Yeah,
police.
just if you put members serve for 3 or ADPCC members serve.
Just be served 3-year terms. Strike 4.
That a member may continue to serve until the member's successor is appointed.
I think we're moving on to D. Previously, it just said appoint a member as chair. I think Dave was there saying it's his recollection and mine as well that only a judge. In fact, it's only been a Court of Appeals judge that's served as the chair, I think, since the initiation of the community. I think it was Judge Winthrop and now Judge Bailey, I think, are the only two that have ever served as chair. But our understanding is the intention was always a judge was supposed to serve as chair. And I think the current vice chair is a member, not a lawyer, not a public member.
Well, we have problems with, it used to say something about him being an active member of the bar.
That's
A
right.
judge is not an active member of the bar, they're a judicial member. So we couldn't have a judge as a chairman.
What's the reason for, I mean, that's fine, but why would you use?
I don't know, Ken, that there was, I don't remember any thought about it always had to be a judge. It just has been.
Okay.
You only have two, I think.
Could that be appoint active members of the bar or judicial members? In other words, is something missing after active?
Yeah, because you're not saying what they gotta be in the bar.
Yeah.
I think the bar members would be after judicial, it's active or judicial members of the bar. Those are both categories of bar membership.
So Bob, I think the idea is though that the professionals should be the ones that are chairing the committee, not a non-member. I think that's just I'm guessing some of our bar members would have a hard time if a non-attorney is the one that's sort of sitting in judgment of them and their legal actions.
Yeah, why would you necessarily need a judge?
Oh, it doesn't have to be.
It's judge or active.
The way it's worded, it could be a lawyer.
It's always been a judge, but it has to be one of the others. So it was actually, I think, just judges, I think, for the first few years of it. And I think Gene might have been the first attorney, but there was not an issue with it. It was appointed as vice chair.
For those of us who get tired of them always telling us what to do.
That's enough.
Based on that statement, you're going to be referred to this.
Is that a serious crime?
I think the rest of it was just cleaning up language. Reimbursement, again, no material changes.
Suggest putting a comma after their services.
Why is it maybe entitled? Shouldn't they just be get reimbursement? Is it discretionary?
I don't know that anybody's ever requested it. I never have. I don't know that anybody's ever asked about it, so. But most of us do it remotely, so it's not the issue that it once was. Like if you live in Kingman, you have to drive to this building once a month. At some point you may say, hey, I'm losing all my time. I at least want my gas being reimbursed here.
But to your point, wouldn't it are entitled?
Yeah,
I mean,
that's what I-
right, they are entitled if they don't
Right.
claim it, yeah, but it's not, because the May is like, well, who decides that?
Right.
Yeah.
Someone's charged the budget and say, yeah, we don't have room for this year.
Well, we may do that too.
So instead of maybe, should it be R?
Yeah.
R type, yeah.
And So Dave, that question would come to you if somebody, committee lives in North Scottsdale and they want to fly, come in for that once a year.
You gotta be 35 miles away. There's rules on where you get lodging, so.
Already built into what they.
Built into.
So the meetings, quorum and voting, there was quite a bit of conversation and wanted to bring it to everyone's attention. We took the quorum from another definition section and used it here. But there is a distinct possibility that this would allow for. And the way it reads is ADPCC must have a quorum, which is a majority of its members eligible to vote to conduct business. So my interpretation of that, and there was, again, a lot of conversation, is those that show up, a quorum is just the majority of those that show up.
I think I raised this because we've discovered that, we've got scores of committees and there's all sorts of different quorums. So we're trying to clean it all up. So separate from this effort, in the code sections, we're cleaning up. But here's what is the intent. Maybe we got to polish the wording. If you have a committee, say, of 11, but 2 of the positions are empty, people have resigned, you've only got 9. Well, if the quorum is like majority plus 1, then 11 would be, the quorum's got to be 50% plus 1. It's got to be at least 6. But if 2 of them are vacant, you'd have 9. Quorum would be 5. And then in some of our committees, you can have conflicts of interest. So maybe 1 or 2 declares a conflict. So that's meant to be, it's a quorum of the members attending the meeting, physically or remotely, eligible to vote. Otherwise, you wind up, some of our committees get into quorum problems because you have a higher number, but they're really not eligible to vote.
So should we add who are physically?
Or attending the meeting, because attendance can be admitted by remote.
Right. Well, and that was a distinction here, that who are attending, and you can attend remotely. So,
yeah. But it should be attending and eligible to vote so that you have recused yourself from that vote.
Right. Is there any reason to have a consistent quorum rule for all these committees?
That's what we're doing. So in all the other committees that are under the Code of Judicial Administration, rather than have 15 different quorums, we're making it all one, and which is this. Opposed to this, but it is attending and eligible to vote.
So that was the problem that I've had, and I did talk with our group because we met on Friday. That attending and eligible to vote. If only 4 people show up, then it's 3 people get to make that decision.
No,
well, that's what attending means. I mean, there's a solution. I'm stealing Stuma's language here. There's a solution out here, and I think we're on the same page. But the way that reads, if we say attending and eligible to vote, if 3 people showed up, 2 people would make the decision.
That's why we didn't put attending. It's eligible to vote.
And our group was vehemently against it. Everybody agreed that there has to be more than just a couple people because of the nature of of what's going on. Like
if you're eligible to vote, and the quorum is, say, 6, you have to have at least 6 at the meeting, one way or the other.
So I think this reads the way you're saying it.
ACJ proposal right now, quorum means the majority of the public council then appointed and eligible to vote.
I like then appointed and eligible to vote. I think the word appointed makes it that addresses, I think, Dave, your concern. If we only have 9 members, but if only 7 are appointed there, then it's appointed and eligible to vote, and that would address both the number in.
So read that let's have it read, Veronica, of its appointed members and eligible to vote.
Yeah.
Other members of APIC who weren't appointed?
No, they all have to be appointed. That's why we all stay way longer. Just not super high priority. I think Daisy was on there for like 10 years or something before they appointed me to replace Daisy. So.
Hotel California.
Any other tweaks or modifications? Looking at you, John. The next one, G, there was some discussion back and forth. I just wanted to flag it for everyone. We had removal, we had change, we had recusal. We weren't certain on what the best word was for a committee member that is kicked out for cause. I think we settled on recusal, but
You want to say terminate?
Well, it could just be for this matter.
Okay,
Or
this
just
was
for this
gonna
matter.
ask.
For a particular matter, yeah.
Oh,
Not from the committee overall.
I'd always thought recusal is something a judge did as opposed, yeah, exactly, as opposed to being directed to do. But that's a me thing.
no, that's right. That was part of the discussion, and that I think ultimately, at least my notes said, bring it to the group to see if the wisdom of the whole suggests if a recusal, removal, change, because I think we wanted to avoid what Bob thought, like they're not gone forever. This is for a very limited, maybe potentially just a
So here's
series.
a momentary inspiration. Instead of recusal, do we want to use withdrawal?
Disqualification.
Something like that. I mean, the current rule uses removal. But it's something other than recusal of it.
Because, yeah, I mean, the chair's not going to order disqualification. They would be disqualified and the chair would take some other action. So maybe it may order the withdrawal. Oh, that's a lot of letters.
Yeah, potentially.
Extension?
They're not abstaining, they're being removed, because abstain, you usually sit and you listen to everything, you just don't vote. This, you're completely, and it happened, I mean, it's never by motion, every time I've seen it, it's always been voluntary, but you just basically sit back and you mute it until somebody waves at you, and then you unmute and you're on for the next one. I mean, that's practically how we do it. But I wouldn't say it's abstaining, because
In the second line. I
Could you
guess it
just
should
say
be a
may
recusal.
disqualify instead of chair may disqualify a member from consideration of a particular matter?
I think you would scratch order as well, it would just be.
Yeah, I wouldn't think, because I thought someone said the chair isn't.
I'm perfectly happy with the word recusal.
That's just Thumma, you
I like,
fan of recusal.
I was not a fan. I still am not a
Okay.
fan. Disqualified.
Last 2 minutes to
Yeah,
make
it
a
hasn't
fan.
changed my mind. I try to keep an open mind, but
Can we say
I
this
think
is a
disqualify.
quasi judicial
Disqualify.
act? So it could be a quasi recusal?
There you go. Yeah, yeah. No, I kind of like disqualify.
So,
I
all right.
abstain from any vote on this issue.
Yeah. And I think that order can be, the court may disqualify a member. You need order.
Yeah.
I think we should recuse Sam.
Well, that's obviously a good alternative, just general.
So, and Veronica, take out order after the chair may.
Good. Alman, you had your hand up and then it went down. Did you want to chime in or jump in?
I was gonna put in input, but I think we just moved past it on this conversation and I don't need to add anything else.
Sorry.
No, it's no problem.
Good. I think the only thing we have left is we try to clean this up to make it read, I think.
Is that F or should it be B? Yeah.
And under H, should that be recused or should it be replaced with disqualified?
Yeah, disqualified. Okay. That's Rule 50.
Right. Anything else? All right, let's take a brief break before we begin the final stretch here, and I will find the word three to mean an 8-minute break, picking up at 2:50. And then we'll pick up, Jessica, you'll be.
Just don't.
All right, we're ready to hear from Jessica on Rule 29.
Yes, so this is work group 2, and we have 2 rules to present to you today. We'll start with Rule 29. So we have Rule 29 and 32M. But we'll start with Rule 29. And the first thing that I wanted to highlight was we did add a sentence at the end of subsection A that says, for the purpose of this rule, records is defined in Rule 123. We're still working on Rule 123, but we wanted to make sure that we had that up front in subsection A. As far as some of the other changes, they're stylistic changes. And then we did, there was some discussion about these purge lists. It sounds like purge lists aren't traditionally or don't seem to be used consistently or regularly anymore. We didn't want to omit them in case they do need to come back and be used again. So that's A. So we are keeping purge lists in there and not removing them. And then the most significant change is, again, that last sentence, for the purposes of this rule, records is defined in Rule 123. And we're still working on the definitional section of Rule 123. But I'll have more about definitions of case file records under these next subsections.
What is a purge list? What are they?
Purge list, what was that?
But they're a list of documents taken out of the files.
Yes, and we don't take documents out of the files. Now files can be destroyed or destroyed in accordance with the retention schedule. But everything now is more like digitized, and they don't have the purge list of things being removed. So they're not really necessary now. But we didn't want to just remove it entirely, if I remember, Justice King, because at some point, maybe someone would want to reestablish or reutilize purge lists. Like, I had never heard of a purge list when I was at the clerk's office, but it may have been because they had not been used in such a long time, but they had been historically.
Do paper case files still exist?
In Maricopa County Superior?
Anywhere in the state, yes.
Yes.
Yeah.
Yes, they do.
My office.
Juvenile court in Pima County or paper.
So is that, any other questions on A?
Yeah, on A, should it, on the first sentence, says the Supreme Court by administrative order, it shouldn't say it's a rule or as the retention schedules are now in the ACJA, and I assume those are the Supreme Court rules.
We have the Supreme Court, we wanted to include that there could be a Supreme Court administrative order and that there's a comma and it should be retention and disposition schedules, and that those are separate, because you're right, those are in the judicial code. If that's not how it's reading.
Well, it says, well, shouldn't it say by rule or administrative order?
I think that'd be better. Yes.
And then just at the end, say for this rule's purposes.
For this rule's purposes. Okay.
David?
Yeah, so this intersects with Rule 94, which we'll be talking about with Work Group 1. And as when we talk about that, you'll hear that we stopped before getting to the subpart of Rule 94 that deals with records retention at the Superior Court. But the reference here in Rule 29 only to the ACJA for Superior Court records is incomplete if we're also going to have a Superior Court role in Rule 94 dealing with Superior records. And one thing we discussed in our work group is, should we even be having a separate Superior Court discussion in Rule 94 when Rule 29 deals with retention and disposition of judicial records? So we're still working on our subpart of Rule 94, but I think we'll, when we report on that, we may need to address another time Rule 29.
David, can you refresh my memory on what does Rule 94 cover?
Superior
Court clerks?
It's Superior Court clerk. So that's the big picture. And it discusses lots of things about what the clerk does, including a section on records management, including what to destroy, how to destroy it, when to destroy it, and the distinction between sort of preservation of electronic records versus destruction of original paper documents. And we've got in our working draft of the part we're not going to be discussing today, a cross-reference to ACJA 3-402. So, I think that this task force might conclude it doesn't make sense to have discussion of what should happen to Superior Court records in two different locations.
Yeah, I tend to agree. I think probably we should, when you reach that point, we should work together so that we don't even potentially have inconsistent provisions.
Yep.
There is legitimate question, but long and Rule 29.
Yeah. Well, and it by way of we started to present on Rule 29, actually, I think 3 meetings ago. And then we held off because we've been continuing some work on Rule 29 and some other rules. But we decided 2 or 3 task force meetings ago that we would take Rule 29, we're going to add it to the end of Rule 123, which is Rule 123 is the public access to records of the judicial.
Yeah, that was our proposal, is having it closer, be more proximate to Rule 123 and perhaps like a 123 point something or other, or subsequent to 123, although I think 124 is already taken.
Yeah, and we'll renumber all of these at the end, but I think it does make sense. And my recollection is there was consensus on that we discussed a few task force meetings ago, because it does make sense if you have Rule 123 that talks about, access to judicial records, to have that side by side with, what are the records that are supposed to be retained.
Sure. And if there's a discussion of the Superior Court clerk duties, you could have just a short sentence that says, comply with whatever the new rule number is going to be.
David, in current Rule 94, it does go into great detail about destruction of case files. But it does have as the preamble, all records in custody of the clerk will be maintained according to this rule, Rule 29 of the Rules of Supreme Court, and retention and destruction schedules adopted by the Supreme Court. So you could do a period there.
Lots of cross references.
Okay.
It's not the easiest rule to, comply with, but, and look, we're talking to, folks in clerks' offices to find out what to do, because there's a distinction between Well, one of the issues is, and I don't know if that's in Rule 29, what it means to be quote unquote no longer subject to modification. Because that impacts the clerk's duties. And does that vary between a civil case and a criminal case?
Yes, yes, it does. And were changes that Judge Thuma worked on last year. And I think there's a current petition pending right now on criminal document retention with regard to, I think, the timeframes for federal habeas and something to that effect, but
It does vary.
it does vary.
Yeah.
Should I keep plugging along?
I had one to follow up on John's suggestion. What the rule or administrative order is important. What it doesn't account for is the Code of Judicial Administration, which is where a lot of these are buried, and I helped bury them. So I think let me suggest either say the Supreme Court will adopt retention and disposition schedules, or the Supreme Court by rule, administrative order, or Code of Judicial Administration provision will adopt those. And there's a rule petition on quorum actually for the committees and commissions where this was raised because I raised it. But that's a different context. And I'd prefer just saying the Supreme Court will adopt retention and disposition.
If I recall, the idea was to give people an idea of where to go find them. But at this point, if they can potentially be in multiple places, maybe that value is not there. And we do cite the ACJA provisions.
If we do there, let me suggest we cite the ACJ broadly up above, because it's neither a rule nor an administrative order. It's something kind of a little in between.
Well, I'm fine deleting the reference to by rule or administrative order or ACJA.
It's shorter.
ACGA really are rules of judicial administration though, so.
It's just clump in a code provision.
Not like that.
They're not administrative order.
That with the folks.
But it says for this rule's purposes, I don't know what's consistent with all the other rules, but do we really need the word purposes even? Isn't it just for this rule? Records is defined in Rule 123.
Records under this rule is defined.
Yeah.
That sounds simpler.
And Justice King, I think we added this too because we wanted it reference to the definitional section in Rule 123. But then as we get farther in this rule, we start relying on the definition in the Judicial Code of Administration for case file records and took out, you'll see as we go on, sometimes there was some, I think, inconsistency where they called things judicial records, official record. And so then we went with the for when it's specific to a case file records as defined in the code.
So should that be except where noted?
But that's different. I think we wanted to do records as going to be defined in Rule 123 because there are going to be times I think where you mean it broadly, but I'm not. So what did you say, Justin Montgomery? What was your addition?
Records under this rule is defined in Rule 123 except where noted.
That would be good.
You know, this is radical, but has anybody ever thought about getting all this out of the Supreme Court rules and putting it into the code? These rules were all developed before a code existed. And over the years, we were kind of trying to get, leave stuff in the rules that directs judges of the courtroom and so on, and put the administrative stuff in the code. I'm just kind of looking at this now saying, man, we're kind of getting the same stuff all over the place. Supreme Court rules, Code of Judicial Administration, maybe this stuff should be in the code.
The principal guidance is going to the clerks. They would be familiar with the administrative code. I think there's some sense in what you say. I mean, I don't think you're gonna see a practitioner hooking this stuff up.
And it's got the 4 buckets that the code has: Supreme Court, Court of Appeals, general jurisdiction, limited jurisdiction, trial courts. And it doesn't do much else. I mean, so I agree completely.
So, Veronica, at the end of that, after Rule 123 be comma, except where noted. Thank you.
The thing for this rule, if the group wanted to propose sunset the rule and amend the code, or would that be substance? Was this rule one of the substantive? I thought this was just styling.
Much you'd have to do with the code. It's already pretty comprehensive in terms of its maintenance. It's got a lot of the directions, about transferring to the Arizona State Library. That is in the administrative code. It's an itty bitty.
It's the only reason to maybe have one sentence just to affirm that the Supreme Court, as one of its core powers, is in charge of records, or just to, one sentence say the Supreme Court can do this.
That may make sense as well. I think there may be some statutory.
Just to affirm the Supreme Court's authority. Supreme Court will adopt retention and disposition schedules. What does that affect?
Yeah, because the court years ago took the position that they're not under the public records law. And that was the policy that in Feldman's day. So it might be good to have something like that. And the records are maintained according to code sections.
And then the access to public records, you still want to have as a rule, because that affects the public's ability to get access. So that still needs to be present.
That would be 123.
Right.
Well, I would still think we need to work through this until if and when these provisions are then moved over into these. But
Are there things in this rule that are not in the AGC?
yeah, thinking about that myself, I don't know. I haven't done a comparison.
It's not.
So- Oh, it's in an
Yeah,
administrative order?
2020-43. It's for the AOC.
So to further, it strikes me then, for everybody's clarity, it probably would be helpful to have everything in one place. Because at this point, we have stuff in AO's rules and then the ACJA. It may make sense to take everything, do a comprehensive approach. And put it in one place.
And then David earlier mentioned there's, Rule 94, but maybe all the stuff should just be brought together and put in some place.
Yeah.
That would benefit the clerks. But I think consumers, they ask them, they have to go 3 places to figure out what you're supposed to do. That's nothing.
One gets amended and the others don't. It's pretty confusing. Excellent.
We keep going through the rule as is, but I have a note here to look at, first of all, what's in the ACJA, and then provision that you referenced, is it ARS or?
The records retention and disposition schedule for the Supreme Court and the AOC. It's AO 2020-43.
The Supreme Court is not in the Code of Judicial Administration, but the Courts of Appeals and the Superior Courts.
Well, yeah, the Supreme Court is like 2-101, 2-201, 3-402, and 4-302 for your court.
But that's sort of the case business of the Supreme Court, not the other side of the house, the administrative branch.
Okay.
Side of the house.
Okay, the AOs, because the retention schedules for at least for the trial courts are both sides. I mean, it's like everything from case records to HR records to probation to.
The primary focus of the Code of Judicial Administration, but Terry, interrupt me, is AC stuff, case stuff. Now, there's other things along the way as well, but that's what we focused on with ACER with respect to retention and disposition. It also addresses business side stuff, but you've got the code sections cited in here, the four, one for the Supreme Court, one for the Court of Appeals, one for Superior Court, and one for
The ACJ code, the ACJ code.
exactly right. I'm
Okay.
sorry. That's exactly right.
Okay.
But yeah, no, I think we should continue just because
Okay.
either way, we're gonna have to potentially move this or consolidate it with the ACJA at some point, but I think we should continue on.
Okay. Sure. So for subsection B is appellate court records and talks about the authority of appellate court clerks. Some of the highlights here was we did remove language it's from B1 in any action or proceeding in their respective court. We took out documents and thought it was duplicative and then just went with records. So we used to have a long list of instruments, books, papers, depositions, and they're all really records. So thought that simplified it. And this is filed or deposited with the clerk as provided in Supreme Court. And again, maybe this is where we want to make a change. We do have Supreme Court administrative orders, references to the Judicial Code of Administration and other applicable rules. So John, I don't know if you have.
No, I have picky points. I think we have a convention when we refer to Superior Court. It's lowercase court and lowercase superior. That's
But
just.
this is Supreme. We're on appellate court.
I'm sorry.
So we do have Supreme Court. We use clerk lowercase c. And then for the clerks for the divisions of the Court of Appeals, we also used lowercase c. And it used to be capital, the clerks.
Can't remember. I recall. Clerks is just the elected clerks.
Correct.
Capital C.
Yes.
So we took that out. This is now lowercase for both. For both that. We removed, there were strange, we thought references again, did have purge lists here. We don't think we had to repeat that, but it is above. And Dave is correct. I wanted to make sure I was correct. It is when you used to remove certain documents from files and not the entire destruction of a file. Took out what we did not think was necessary anymore, these references to certain rules of civil appellate procedure and criminal procedure. Then for subsection 2, this is where we don't see, so transfer to Arizona State Library Archives and Public Records. We went, I think it took us like 2 hours to determine all the different various ways that this is referred to in statute, but got consistent that it is Arizona State Library Archives and Public Records, although it's a division of the Secretary of State. And then for future reference throughout the rule to use the acronym LAPR. Again, we went from capital C to lowercase c for these clerks for the appellate court records. Must transfer original case file records that must be permanently maintained to, and we took out the full name, to LAPR. And we took out the pursuant to and a lot of language there and just say under, and then we reference the codes of judicial administration, ACJA 2101 and 2201. Aaron Nash did raise with me, and I think makes a good point, is the next sentence we might want to look at rephrasing. What we wanted to do here was we got rid of the shall and went with must. And then we added paper and the reason why was not everything, and I know people don't believe this, but not everything is digital. Yeah, there is still paper. I've talked to Aaron. We know there's still paper. I think the water case is in paper. There's other courts that have paper. But it may read right now, our intent was not to, if you have something that is digitized, so you still have like a lot of pro pers that may file in paper even now in Maricopa County Superior Court, or you could have, I think, even at the appellate level, pro pers that could file on paper. The intent was if the courts digitize that then they can still destroy the paper and the digital record is what is transmitted to library and archives. So we may want to clean that up here instead of we had must retain original paper and digital records. What we wanted to mean by that was you might have some stuff in paper, it stays in paper, you never digitize it, you need to retain that. And according to the retention schedule, it could be permanent preservation and you have to maintain that until library and archives can accept it. For the paper that you've digitized or records that are only in a digital form, like e-file, you have to preserve that, clerks, until library and archives is able to accept them. And the reason for able to accept them is currently library and archives is not able to accept any digital records. There's no digital portal to accept digital records. And that might be surprising, but they don't. And then my understanding is with some paper records, and I say some because I don't want to speak for every entity, that there's space issues and they're not taking paper. So, yes.
Just looking at Code of Judicial Administration 2101, which is the Supreme Court part of this, right?
Yes.
C3, paper case files and administrative records, it directs right now, paper case files and other records designated as having a permanent retention period, or I'm sorry, a retention period of permanent shall be transferred to LAPR. And then with electronic, the provision just before it, electronic case file, because you're right, LAPR doesn't take electronic stuff, which is shocking, but electronic case files designated as having a retention period of permanent must be transferred to LAPR at a time when LAPR has the capacity to accept electronic records. I'm pretty sure the Court of Appeals counterpart says that exact same thing. Now, if they're, so I mean, the current requirement
should be up on the Court of Appeals.
Is different
right now, sorry.
Well, but that, I think 2 is what is that? B2 is for both, because 2101 is Supreme Court, 2201 is Court of Appeals.
Okay, yes, it's supposed to be both.
I think they say the same thing. Right now, under the code, each court has to transfer paper files to LAPR, and for electronic, they don't because LAPR doesn't take.
And I had heard, and maybe Aaron, I'll ask you, is I don't know about any of the appellate court clerks, but like for Maricopa, they told Maricopa County, we don't have room for your paper.
And that may be, we'll get to that chunk, but I'm just saying what the code says right now needs to happen. And it's mandatory, not.
It is a mandatory.
Optional.
I think we talked about later in the rule is there used to be, we initially started with they will attempt to transfer, or that was at one time in the room. And then we thought, well, what does that really mean? Like, do you attempt, like you give them a telephone call? So we're trying to rectify that because if it's must,
right,
but they won't take it.
And if all I'm saying is we ought to have the code.
Should we amend the code?
The same.
Okay.
And I don't know which one's right. On electronic, this is exactly right because they can't take anything electronically now. And hopefully that will change. But for the paper, we'd have a code section requiring something different than what this.
Okay.
What about microfilm?
Microfilm is C4 of the same thing. Until national standards for the long-term preservation of electronic records are in place, records transferred to LAPR pursuant to the provision of this schedule shall be in paper. So it's saying you blow it back.
So we pretty quickly got into an example of what we were talking about where the rule says requires one thing, the code says something else. And this is an example where the ACJA or an admin order makes more sense because the court rule, which is difficult to change, it takes a long time, requires something that the state library won't allow us to do. We show up with our boxes of paper and they say, turn you away at the door. You don't have anywhere to put this. So that's where ACJA or an admin order would be more flexible to adapt to the real world.
But I think that's why we did intentionally phrase it, although I could see where it was confusing, that each court must retain original paper, maybe it should be microfilm too, and digital records for permanent preservation until they're able to accept them. And we thought that encapsulated the inability of electronic portal or the, oh, we have no room at the inn type thing. And so that the clerks just can't be destroying records that are designated as permanent. No
First
matter
and
what
foremost,
Lapper
first
says.
and
I mean, I'm just saying,
foremost,
like, you know, like if they said you can't take it,
100% agree.
that's, but I don't know what, I think if there's a better way to say it, or if we really need to think about where this all should be consolidated for consistency's sake, but that was but by no means I wanted to be clear for appellate courts. The intent was if something came in paper and you scanned it and turned it into a PDF, it was not the intent that the court must keep the paper and the digital and send both over to Lapper. Because isn't there the provision that the digital becomes the official court record for paper documents?
Why don't you just make it an or, paper or digital?
That's what we had talked about, right? If we were going to propose, if that made it clear, paper or digital.
Yeah, because if it starts as paper and you digitize, it's now digital, so it's one or the other.
Yes. Yeah. So I think we want the and as the or. Each court.
For what it's worth, in our working draft of the provision of Rule 94 dealing with Superior Court records, we go through this, talk about paper records, if they've been digitized, they can be destroyed. So I don't know if it's, but I think this discussion is just, in my mind at least, confirming the utility of a very simple set of rules, which just refers everything to the ACGA, because they're so detailed. I mean, if you look at the section 3402 on Superior Court, it goes for pages and pages with charts and graphs. This could change at a moment's notice. Why try to codify them in a set of Supreme Court rules, even in a more general basis, when it's going to be modified continually over time?
Yeah, and I take that point too. I'm wondering if, given the ongoing discussion, it may be beneficial to, Dave, maybe we can, if we want to take these provisions and have somebody kind of look at them to.
Did a little task force too.
I know, I hate to say that, but I know. Another group, or, I mean, I can be a part of it too, but we may be looking at duplicative provisions that are already in ACJA and maybe do a compare and
And
contrast.
administrative orders.
Yeah, and administrative
Right,
order.
all together.
It would help to have like clerks and stuff on that. But they know this stuff a lot better than we do.
Yeah. Okay, well, does everybody agree, just trying to make sure I understand, that maybe it's a benefit to have moved this language 29 and to make sure everything is just consolidated under one group in the ACJA? Okay,
Actually make Supreme Court rules shorter.
yeah, that's good. Well, in that vein, why don't we table this discussion and see if we can get another group together? But then I do think we should, once we have everything consolidated into a proposed ACJA, maybe we present this to the task force, so they're in the loop. Yes.
So the idea would be to move a lot of this into the ACJA, but still have something accessible to the public that says, hey, if you're looking for court records that we have to keep, go over to this other set of rules and take a look at it.
That's what I would think. Yeah, it would just be really maybe a 1 or 2 sentence rule that would say, for more information about retention and disposition of court records, see ACJA, whatever.
A roadmap, kind of, hey, go look here.
Okay. All right. Well, in the interest of time then, I've switched gears. Let's go ahead and table that. We'll work on that separately. And then maybe Jessica, do you mind presenting Rule 23M, and that way?
Oh, no, not at all.
This should.
Last word.
I know. Okay.
So I will move us to Rule 32, which is part of the Rule 32 is organization of the state bar, and subsection M is meeting and records. And it previously stated the state bar will conduct meetings and maintain records in accordance with Supreme Court rules and administrative orders. That's what we're proposing for it to state now. That's what we're proposing the new version to be, that the state bar will conduct meetings and maintain records in accordance with Supreme Court rules and administrative orders. The change is it's currently says the state bar will conduct meetings and maintain records under public access policies adopted by the Supreme Court. The work group thought that, truly right now, there's 2 administrative orders for the state bar. That one applies to the open meeting policy, and it's in an administrative order form. And then one is the public record policy, and it's an administrative order. And so we thought it was tighter to reference administrative orders and then possible Supreme Court rules, as opposed to public access policies, which we felt could be looked at by the public as perhaps not as stringent as a rule or administrative order.
One thing, these administrative orders that are really long-lasting policies, we always have intended to either breed into the rules or breed into the code. Because administrative orders are hard to find, if they're done by year, we don't really have an index by subject. And that's a long-standing policy now, so we should put it somewhere besides in an order.
They get modified.
Well, yeah,
Orders get modified, you cannot.
Well, we try to track, each time they're modified, we do track it, it'll say, but I think sometimes we can't keep up with the administrative orders, but at some point we should bring them somewhere more codified than an order.
Well, then
It may not affect this, but this group should decide whether a state bar rules, we have all the other stuff about the bar, why wouldn't we have their public records and their public meeting requirements in Supreme Court rules?
We have no problem tracking those 2, Dave. We know where they're at.
we know where they're at, but they're from 2017, and I did talk to Justice King, and we've talked a bit about in our work group about, those should be looked at and updated. They were issued by Justice Mills, and they haven't been updated, not to say that they have to have changes. But then we were like, okay, well, we're here for the rule. But I think what you're saying is, should those be in Supreme Court rules? Or is it something we have rules listed here and administrative orders? Would you like us to add something that would encapsulate the code, or do you think the code is a rule?
I think my first reaction is all the other stuff about the state bar is in the rules, Supreme Court rules. And it just seems to me why are we just taking those 2 and keeping them off in an order? And they're both very substantive rules. I'd put them in the state bar section.
Are they lengthy?
They're 2 pages.
2 pages.
Not
They were
terribly
linked to
lengthy.
the email.
They're not as lengthy as the retention schedule.
Oh, yeah.
Judge Skinner, that's like,
They can't be that like.
Trade off.
Are they up to date where they could just be taken into the hotel? basically?
I don't think I've heard anybody propose changes, but they're probably put them in.
Yeah, I'm not aware of any proposed changes or anything like that. Yes, the group did, I guess, probably didn't take a substantive look at the actual underlying AOs. You just look.
we didn't. I provided them. I know Mark and Justice King have them, but we kind of took the position, that may be a project that once we got the rules done, to look to see if there needed to be updated, or is there anything antiquated in them that like now electronic, that we say paper or.
Yeah.
Jessica, they were linked in the cover email that went out with the meeting materials,
Yes,
and they are kind of wrong.
the AOs.
Yeah.
Yes.
Well, the appendices to the AOs.
And again, if they're in administrative order, they're easier to change as opposed to if they're codified. It gives the court a little more flexibility. I will admit, I have not read those AOs and you know, appreciating detail, but I know that was an important one.
I don't think there's been any change since they were adopted.
No, but to the judge's point,
Oh, you're right.
We would
It's
probably-
easier to do them.
we haven't really looked at them. I mean, if we're gonna incorporate them, I would just say if we're gonna incorporate them in the rule rather than just cut and paste, since we're doing this project, I would think that we would actually take a look. We haven't really taken, probably because we haven't had really issues with them, but we haven't really taken a substantive look at those, I don't think, in some time.
Would it be really dangerous to just refer to the numbers, administrative order such and such?
Yeah, because if they do change on the order, the number's not right. Now, whenever we change an order, we'll put, and change the new order, so it's there, but they're not as easy to find. We have quorum rules for the bar and all that stuff, and then we don't put the major policies. It doesn't make any sense to have these major policies for the bar somewhere else.
Does the bar link any of those things on its own website?
It does. I was looking right now.
I'd say.
Are they public meetings? It's on the website, on that for sure.
Yeah, the open meetings or the public meetings, that I know is on the website. I was looking for the public, if the public records policy is on the webpage.
Comes up when we get requests for public records, because usually quite often the request is updated by request your cite theirs on the statute instead of they assume that applies and it doesn't.
It doesn't appear the public records policies.
And, direct the state bar to publish on its website what those are. That way you wouldn't have to. Perfect. It's going to be done by administrative order, but the bar shall publish it on its website. So that way the public would know right where to go. You don't have to worry about updating the rule.
Our website cross-references Rule 32M and actually refers to policy adopted on April 5th, 2017.
Both of the policies went into effect, I think, January 1 of 2018. And I think they did correspond to a rule change.
Yeah.
32M, yes.
Well, the whole rule, I think, changed it.
Well, 32.
Being this far exceeded 30 seconds.
I thought if anything, we got rid of what are public access policies adopted by the Supreme Court, and kind of wanted to be clear that it would either be a rule or an administrative order.
Well, do we want to, as John suggested, just add a reference that the shall be made available on the state bar's website?
And they both are. They're both linked.
Well, the administrative orders helps.
Yes, both of them are on there. They're both linked.
Administrative order.
Both under records and meetings, they're both linked on the state bar's website.
It would be sufficient because of the public state bar site. Begin.
I just Googled state bar public meetings and it went right to it.
What about public records?
Public records too. So it's right.
Would we still want Rule 32M though to say that the Supreme Court sets the rules?
Right.
And they can be found on the state bar website?
Yeah.
And the state bar website starts with Rule 32.
Mm-hmm.
So
how are we changing?
that would be a sentence.
The way you changed it is perfect.
But do you want to add that the bar shall publish it on their website?
Or after administrative orders, just say it available on the state bar's website.
Are available.
That are available.
Shall be available, or that must be available.
But doesn't that say that the records are available?
Say the state bar must post administrative orders, the administrative orders regarding public meetings and records on the state bar website. Post the administrative orders regarding public meetings and records.
Make it a little shorter. How about us post these administrative orders? The ones we just talked about in the last sentence on its website.
I like it.
All right, that's 32 hours.
Joel already took
Done. So that's all that we have today. I don't know, Justice King, if you wanted to talk a little, were you going to talk at all about, I think, our next steps on Rule 123?
So, so Rule 123, which we started presenting early on in this task force many months ago, we have been, well, and Mark and Marita have been really helping in the background to back to revisions to Rule 123. So we will jump back into Rule 123 the next time we're to put that.
All right, David, as our relay anchor, we are going to hand you the baton with a spark of hope and rely on you to
Well, thank you.
bring us to the victory line.
Yes. I'll try and speed talk. How about that? Well, good news is we don't have much to talk about today. Yeah, just a refresher. At the last meeting, we addressed Rule 93, which was an anachronism talking about things that court administrators maybe once did and no longer do. And so we've been working on a new version of Rule 93 that might actually apply to 2026 and beyond. So at the next meeting, we hope to present that to you. So Rule 94, instead of discussing court administrators, discusses superior court clerks. And as I mentioned earlier, there's a whole section at the end of Rule 94 that deals with document preservation and destruction. So we're not presenting that today. So all we have to address is the beginning of the rule. And there, with one exception, our changes are all stylistic. And so A talks generally about the duties of the superior court clerk. We didn't make any meaningful changes at all, even stylistically there. So that's part A.
No, David, on A2, pretty sure there's an administrative order that uses the word coordinate with the presiding judge, the budget. You might want to look at that because we used to have battles between the court not telling the clerks that they're going to get new divisions and then the clerks being surprised, didn't have the clerk. So I think there's an order that requires the coordination of the budgets. Now, maybe that's cheap.
Is the existing rules word. I have no problem with coordinate if that reduces tension. That's not something we discussed in the work group. That makes sense to me.
David, in 3, can we scratch the word such? Read clunky.
Yeah. Okay, big substantive change in 1, when open. The existing rule says that the clerk's office must be open during business hours on all days except Sundays and legal holidays. And we changed that to weekends to comply with existing practice and maybe historical practice. Nobody in our work group was aware of any requirement or practice that the clerk's office was open on Saturdays. So I guess that's something we need permission, Justice Lopez, to propose that revision.
Dave, would you please repeat that?
Yes, the existing rule says that the clerk's office must be open except on Sundays and legal holidays. We've changed that to weekends and legal holidays. So we're giving permission to the clerk's office to close on Saturdays, as they've all been doing, to our collective knowledge since the beginning of time.
Very gracious, and I have no objection.
You know, there is another, there are also orders that require the clerk to have deputy clerk physically present, like for election nights, election contest. And so I wonder if we need something like, or is it directed by the Chief Justice or something like that, because the chief issues that order. You know, we had issues about filing middle of the night on election night.
Isn't that what the statutory reference though is?
No, I don't think so. I don't know what that reference is, but I know the chief issues the order saying you need to have a judge and a clerk available.
For the last votes.
Yeah.
In the district. Yeah.
Well, so they vote or because you get a contest?
Since the last few elections were, if it was election day, it wasn't the deadline for the contest timeframe. It was until the last voter votes.
That's extending hours.
While the polls were open.
Yes, for the deadline for election contest, if
Right.
one came in at like the end of the day and the judge decided they needed an emergency hearing, so like it's the cutoff day for an election challenge. It's like a signature challenge or an eligibility.
But whatever it would just be or as directed by the Chief Justice. Because there could be other circumstances where the chief saying you need to be open.
But you can just say at the end and accept as the court orders.
There you go. Well, you might want to say the Supreme Court.
We define Supreme Court, we define court as being the Supreme Court.
Capital C, right?
Capital C court.
Maybe instead of as the court orders, because that it should be or as.
It would be or it.
Now, the Constitution says the Superior Court's open at all times. But I think the difference here is the presence of a clerk or deputy clerk. I always
and we've addressed that in some other rules. Okay. In terms of accepting filings, et cetera. Yeah, I think this is the physical office. Unless there are more questions on 1.
I just wanted to say there have been times where, at least in Maricopa County, the clerk's office has done weekend hours, but generally it's been limited to marriage licenses, certain events related with obtaining marriage licenses, especially when there was a backlog with certain customer service days for marriage licenses and passport applications, but it wasn't required. Is that
This says must be open, so wouldn't that be permissive? That's limited to.
Yes, yeah.
Very warrant to do this.
So if I can move on to 2, not a substantive change, but a wording change, and I thought we wanted to discuss this. Can we put on the red line so folks can see what I'm talking about? Okay, so what the rule now says, as we're proposing, that will allow the clerk to grant motions and applications that do not require a judicial officer's order. So very general and broad. The existing rule, we thought, empowered clerks to enter orders that they don't, and it was very specific. So they could issue orders for men's process, for issuing final process to enforce and execute judgments, for entering default, etc. That's a lot of that is not what clerks do. Judges do it, but they're things that clerks can do. So basically, what we're proposing is, again, not a substantive change, but a simplifying and more accurate provision is that they can issue orders if except for those orders that require a judicial order. So maybe we can go back to the clean version so people can comprehend what it actually says. All right, so very simple. Any questions, discussions? If not, we can go on to a court docket.
You know, David, there is a process by which we've set up where a judge can authorize the clerks to issue orders that normally would be done by a judge, but where there's no discretion. So like the judge will set up a template to say, these apply maybe somewhat more to limited jurisdiction courts, but it might apply to clerks too, where the judge would say, if somebody got cited for failure to have insurance, proof of insurance, they bring it in, you can grant it. So I don't know if we need to tweak the wording at all to allow that sort of thing, because it would normally require a judge's order, but the judge does it in a sort of a general order for the clerk.
Yeah, I think that would mean that that's not something that requires a judicial officer's order because of this unique authority that's been provided.
All right.
Dave, what about the probate functions that clerks do, probate registrar and informal?
Are those motions and applications?
They're for an informal probate. Yes, it would be a petition.
And do they require a judicial officer's order?
Not in Maricopa County.
Not in Maricopa.
So this would say a clerk can do it. Yeah, we're getting away from this very specific listing. It's in the current rule that was inaccurate and giving a lot more discretion.
I say not in Maricopa County because I thought there was an administrative order that delegated the authority to the clerk's office for the probate registrar.
It's a rule.
Is it rule?
But it might be a local rule.
We do that in Pima County as well. Yeah, for informal probate, like issuing letters and stuff. No, yeah, I don't think the judge gets to follow that.
Is it by rule though? Do you know?
I don't know. I don't.
It's either rule by or statute. It's not an AO.
Okay.
So look, I mean, we can make this longer and say, and as provided by court order, AO, whatever. If people are concerned this is too generous, but I think that this would allow all of these circumstances that we're discussing. Well, 4 minutes left. Should we go to court docket?
Yay.
Yeah, let's go as far as we can in the next 4 minutes.
Yeah. So we did a lot of language cleaning up here to, I think, encapsulate what the current rule intends. And there's really, as we learned in our work group meetings, there's really sort of two types of dockets. There's what a member of the public might see if they log in and on the court website see the docket, which has everything that's been filed or issued. But there's also what the clerk maintains as the docket, which includes additional information that may not be apparent to the public on the website. And so I think this covers both accurately and completely. At least that's what we were hoping. So I correct me if I'm wrong, work group members, it's that other record keeping, the register of actions that goes beyond the filings and the issuances in a particular case. So hence the note there, do we need this other record keeping section that sort of goes beyond what at least, we lawyers think of as the docket?
Well, I think the register of actions typically refers to the computer system's register of every action entered into the computer system. And you can go back and audit where people did things. Whereas the docket is what you would think of as the public record of proceedings in a case. So if that's what it's referring to, we do want that. That has to be kept.
And Dave, I think that is what it's referring to.
I don't think it's a may. And the other, let me ask the clerks here, our case numbering, is it always consecutive numbers? Like if the computers go down and they're doing things manually, do we number them differently under those circumstances, then go back? I just wonder if you need the word consecutive or not.
And I had a question. Each case type, it's not just one case, continuous case number for all filings.
No,
it's by case type.
Yeah, it's given a certain letters designation of the case type and then a number. But it would still be consecutive case numbers right here.
Yeah,
we discussed that on the workforce, and it may vary by county, right? Maricopa will give a CV for civil and a CR for criminal, and et cetera, et cetera. And then you have the lower court appeals, which get their own. But within that case assignment, my understanding is they're numbered consecutively.
Well, typically, I'm just thinking of, we have procedures where if computer systems go down in a court, I'm not sure how they're then recording it on paper. I don't know. Maybe consecutive is important. I'm not sure. That's the way they're done. in the general course of affairs.
We could change it to a unique case number.
It'd just be case number.
Well, see, Jessica, you're the only clerk on the ranch. We could double check with the clerks. Consecutive might be fine. I just not sure it's always 100% that way.
You mean consecutive? I don't know if it is 100% consecutive. I know that case numbers, but it's really like you have to go paper. I don't know.
Sometimes do blocks of course, so Maricopa County would do a block of search warrant numbers at the start of the year. And then give those to different judges that search. So that nobody duplicates a case number. So they're not technically going to be in consecutive order because one judge isn't going to use all of their block. So they're issued consecutively 1 through 10,000, whatever it might be. But there might not be record.
Rather than us to try and decide it today, when we get this, I suggest we take this section and send it out to the clerks like we did the administrators and get them to make comments now. And we could revise before we put it out to the public. Because we need more clerk input on some of these technical details.
Based upon what Aaron said, it does make more sense than to use unique. Because it doesn't sound like consecutive.
Yeah, I'm just worried if we put it as an absolute, there's going to be exceptions to it.
But I can't, it's got to be the rule that each case is going to have its own case.
Oh, yeah, unique number. Right.
And that's really what's important.
But in criminal cases in Maricopa County, I guess you could say that the last 3 digits are the unique defendant ID. I know some counties, each defendant gets a separate case number.
It now does it that way.
But the case still has a unique number.
Yeah, and we would call those last 3 digits at the clerk's office the unique identifier. Like we'd sometimes say, or, like we would, need that, because you could have defendant 2 that might have got a ceiling, but 1 and 3 did not in that, but they still have the same CR number except for the last 3 unique identifiers, I guess you could call.
Was that 1 case or 3?
It's 1 case number, but with 3.
Oh, there's a 1 case
That's how
or
they
3.
do, how you do it, Ken?
They separated.
We have
cases
3
or they're all
separate.
1 case.
They're all 1
So-
case.
Your indictment would have 3 separate case numbers.
We'd have 3 separate indictments.
Oh, really?
Yeah, see some cases, I think Pima does it that way, don't you?
No, we have defendants 1, 2, and 3 with one CR number.
So if you put the CR number in, like in the case management system, then all files.
Yes.
And then you'll see like 001, maybe someone might have, you'll find out one of them took a plea early on, so
very
001
complicated.
would be out of the case.
Right, yes, early on, yeah.
All right, David, I think we'll stop there. We're past our appointed time and we still have call to the public. We may have someone who wants to speak. So with that, I want to remind everyone that our next meeting is June 12th. So we will see each other then. As anything else for the good of the order before we turn to the call to this public case?
Okay, well, the final item is the call to the public. And Veronica, there's nobody here. Well, with that, we can go ahead and adjourn the meeting. Thank you all for that diligence and